Poxo.
It also same.
Item number 8.
For short password.
Poxo.
Item number 9.
My lord, I am follow that. May I, my lord? My lord, the prosecution case is that on the basis of a secret information, they went to the PO and found a man standing beside a bicycle, motorcycle,
Yeah.
having one cartoon box.
Yes.
So subsequently, the raiding team led by the IO issued a memo of detention. My lord. So since that copy.
What is the name of the accused? Petitioner.
Petitioner name is, my lord,
Sajjad Alam.
Sajjad Alam.
Yes.
This is the first application, my lord.
When he was arrested?
He was
February 25. 5th February 25.
6th of February 20.
6th or 5th?
February 20.
5th.
No, my lord. 5th he was detained and the FIR was arrested on 5th and the FIR was registered on 6th, my lord, next day.
Huh? Where is the FIR?
My lord, at page 10.
Page 10. 6/2/2025.
Yes, my lord. But arrest was made, if my lord sees the arrest memo at page 16, it is 5th of February. Since it was night, my lord, at 11 o'clock, 11 p.m. But the memo of detention was issued to the petitioner at 7 p.m. My lord. So the since all these days, my lord, have already gone through the Supreme Court judgment regarding grounds of arrest. My lord will find from the CD, if CD is placed, to take up. I would request to take up the memo of detention first.
Yes, next. I will see. Next, what is the ground?
My lord, next is, my lord.
What has been seized from you?
My lord, there was a cartoon box. In that box, my lord, 100 bottles of cough syrup, my lord.
100 bottles of cough syrup.
Cough syrup was there.
100 ml each.
Yes, ma'am.
Correct.
My lord, I am placing reliance on, my lord, section 36(3) of BNSS Act, my lord, wherein, my lord, since my lord filed from the page 16 memo of arrest, it is of old format. And after July 1st, 2024, police has to issue memo of arrest as per section 36(C) of the BNSS Act. I am placing the sample of this, my lord. This has to be. This is the arrest memo, new arrest memo, my lord.
Yes.
After 1st July 2024, and since I was arrested in the year 2025, police has issued arrest memo, the old format, where the ground of arrest is not there. Moreover, if my lord comes to memo of arrest, column page 16 for once. 1E, name of relative friend whom the person taken in custody intends to inform. The petitioner tells the IO that his father should be informed, but there is no reflection that his father was informed. None of the columns, the 2C is blank, column 3 is blank. In this regard, my lord, I would like to place a judgment of coordinate bench. Page 10, my lord.
Yes.
Page 10, seventh paragraph. It appears from the materials in the case diary placed by the prosecution that the memo of arrest does not mention the grounds of arrest, nor the fact that the accused has been informed of the grounds of arrest. It appears from the memo of arrest that the case reference with offense committed has been left blank by the arresting officer in respect of the petitioner herein, and only GD number has been mentioned. Court was referring to para 4 of the memo of arrest, serial number 4, 3 and 4, man.
Yes.
Yes. Now, my lord, second ground is, my lord, if my lord takes up BNSS Act, section 36
Yes.
for once, my lord.
Yes, read.
Section 36. Every police officer, while I would like to mention that section 36, the section 41 of CRPC has been replaced by this section 36. Every police officer, while making an arrest, shall A. bear an accurate, visible, and clear identification of his name, which will facilitate easy identification. B. prepare a memorandum of arrest, which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. Here, my lord, I don't know whether this person is a respectable member of the society or no. He is not the family member. Second is countersigned by the person arrested. C. inform the person arrested unless the memorandum is attested by a member of his family, and that he has a right to have a relative or a friend or any other person named by him to be informed of his arrest. So this 36C has been incorporated by this BNSS Act. If my lord comes to section 41 of CRPC.
Yes.
Arrest for persons.
Yes.
41. When police may arrest without warrant.
Yes.
Any police officer may, without an order from a magistrate or without a warrant, arrest any person who commits in the presence of a police officer a cognizable offence. B. Against whom a reasonable complaint has been made or credible information has been received or a reasonable suspicion exists that he has committed a cognizable offence punishable with imprisonment for a term which may be less than 7 years or which may extend to 7 years, whether or with or without fine. If the following conditions are satisfied, namely, 1. Police officer has the reason to believe on the basis of such complaint, information or suspicion that such person has committed the said offence. 2. The police officer is satisfied that such arrest is necessary, A. to prevent such person from committing any further offence or for proper investigation of the offence, or to prevent such person from causing the evidence of the offence to disappear or tampering with such evidence in any manner. Now, my lord, 41A and B, the procedure of arrest and duty of police officer making arrest. Every police officer, while making an arrest, shall bear an accurate, visible, and clear identification. This para is there in 36 also. Now, my lord, second, prepare a memorandum of arrest which shall be attested at least by one witness who is a member of the family of the person arrested or a respectable member of the locality where where the arrest is made. Same with 36. Now, countersigned by person arrested. Same with 36. C. inform the person arrested unless the memorandum is attested by a member of his family that he has a right to have a relative or a friend. So, this particular section has been violated while issuing this. First, my lord, the memo of detention which was issued at 7 p.m. That too also violates the grounds of his being detained.
Yeah, memo of
Detention.
Huh.
Which was issued at 7 p.m.
Where you find it?
That is in the FIR written, my lord. I don't have the copy. That's why I requested my lord to.
FIR?
Yes, my lord.
You are not disclosed the FIR here?
Yes, my lord.
So, where is that?
My lord, page 11, my lord. Para first paragraph, my lord.
Huh.
10th line.
Huh?
10th line from top.
Huh.
Then I issued memo of detention.
Issued memo of detention with the reason to believe that he is in possession of possession. Yes.
So if my lord sees the memo of detention, my
Hmm.
lord will not find any grounds why he was detained for such a long hour.
When the memo of detention was issued?
My lord, on that day, on 5th of February
Hmm.
at 7 p.m.
Hmm.
Unfortunately, I don't have the copy of that, my lord. We'll find it.
So that's why I'm asking where you are submitting, which document you are submitting?
My lord, the memo of detention is there
Huh.
as per the
Now,
FIR.
where from you submitting that 7 p.m. the memo of detention
I
was
was
issued?
informed by the trial court lawyer that it was submitted on. I don't have that document, my lord. That's why I'm requesting to verify it from the CD.
Hmm. Yes, then?
Now, my lord, section 50 ADPS Act.
Hmm.
There is no time mentioned in the notice issued by the investigating officer, my lord,
To whom?
to the accused.
What?
Section 50, my lord,
Huh.
it was issued, my lord.
Where is the section 50 notice?
My lord, that also I have been informed by the trial
So
court.
go and argue before the trial court. If you're not having all document, why you are submitting here?
My lord, that's why I'm requesting, my lord, to just verify this information with the CD, my lord, from the CD. Thank you, my lord.
For your benefit, the court will take the record of the prosecution, or if you want to make out a case, you have to bring all the documents on record.
My lord, those documents were not.
Where from you read the law?
My lord,
You
those
plead that,
documents
and
were
the
not handed over to me.
court has to prove your all the pleadings from the other side document. This is the law.
My lord, that's why I'm asking, my lord, just to verify whether.
Sir, what you are submitting, you should submit the fact which you are having the knowledge, having the facts. This is the facts you have to prove. Law, you need not to plead. Law, you can argue. With regard to the facts, if you want to argue on the facts, must be the facts on record. If the law is changed, I don't know. Then you give the book. If the law is changed, then I will also go through. The fact is to be proved from the other record, not from the record of the plain petitioner.
My lord was better than me, my lord.
Then?
All documents are not supplied to the.
Why
accused
that's a since
before-
beginning.
Before the charge is framed.
That's why since beginning I am hearing the same thing. The document is not supplied. Once the accused has been arrested, he has been sent into custody. What are the documents filed by the prosecution? If the prosecution is not been supplied, you have a right to apply the certified copy.
We have applied the.
Where is the application? That's why on the last occasion, I know some of the advocates give the certified copy form. It has been denied. I will pass a appropriate order here in now. Show me. It has been denied for giving the document.
No, no, no problem. I will tell you.
Show me. Where is the certified copy of the form?
That is submitted before the
So,
court, my lord. This is the list, my lord, that was applied, not to those which were provided to me, that is mentioned here.
so what has
There is
happened?
other things they have not provided, my lord.
So what has happened if it's not provided? What you have done?
My lord, it is.
The first page, whatever documents he has applied for, it is in the first page. Now, if any documents are the certain documents which cannot be given, if it is not exhibited. Because in that case,
No, exhibited with regard to the relying document. With regard to the document with the prosecution, you cannot deny.
Actually,
Then-
my lord, in this case, my lord, may I, my lord, in this case, my lord, charge sheet yet to be submitted, investigation still in progress. That is why, my lord, the,
So, charge sheet is not filed.
yes, my lord, that is why, the copies of the, prosecution copy is not supplied upon the.
What checklist you want? How the checklist will be given? What checklist? Unless the charge sheet is not filed. What checklist you will be provided?
All documents are not available with me, in my record.
You have applied, what you just stated that you have applied. Checklist, what checklist you want?
My lord, please, sir, checklist are there when 41A notices are served. If it's the case under up to 7 years, if the person is arrested, then you have to give a checklist, forward a checklist with the arrested person. Why he has been arrested. So that is the checklist.
I don't know what type of the,
My lord, the documents
what
are-
type of the
here, my
defense.
lord, Here, the documents are provided only after the charge is filed. All documents,
Correct,
not before that.
correct.
After charge sheet is filed, my lord, few documents are provided like CFSL and the arrest memos and seizure list, they are provided with the charge sheet, my lord. So it is difficult for the defense to grab those documents and produce it before the court. That's why we request the honorable court
Yes,
to verify
yes,
the
yes. Next, what is the,
information with the,
next, what is your case?
my lord, that also I don't have the document annexed, but it has derived from the record that rule 14
Hmm.
of the independence, rule 22. Rule 14, my lord, for once.
Hmm. First, you show me in rule 14, what is the violation? Show me what is the violation from the record.
14 prescribes that mandates that the samples which are sent to the CFSL,
Hmm.
the report has to reach by 15 days.
Correct.
And a grace period of more 15 days
Correct.
is provided. Now, last, when the lawyer of the trial court checked with, I asked him to check with the record whether any CFSL report has arrived or not. So he informed me that no CFSL report has arrived. So standing, and he also informed me that CFSL report was sent on either 10th or 12th of February.
Hmm.
Now we are standing today on 22nd of May.
Hmm.
More than 90 days have been passed and the CFSL is yet pending.
Hmm.
The report is yet pending. So
Hmm.
this directly violates the provisions of Rule 14 of 2022.
Correct.
NBS Rule
Then,
2022.
yes, next.
Now, my lord, I would like to press on this rule.
Yes, why?
My lord. My lord, the case was initiated on 6th of February 2025. my lord.
Correct. When the FSL report was, when the certificate of correctness was
Certificate of
received.
correctness, page 49, my lord, certificate of correctness done on 10th of February 2025.
Correct.
And my lord, the sample was sent to the CFSL my lord, next day, that is 11th of February 2025.
Where is that?
My lord, page 59 and 50 is the certificate of correctness, 59 is the memo, my lord, through which the
Yes.
sample was sent to the CFSL.
Certificate of correctness.
Yes, ma'am.
Yes, when you receive the report. Where is the report?
There is no report till
So?
my lord. That is why we are waiting to submit the charge sheet, my lord.
So, 15 days, 1 month, now we are on February,
That's true. That's true, my lord. But
then, and first thing. Second thing, kindly come to the arrest memo.
yes, no.
Arrest memo, got it?
Arrest, memo of arrest. Yes, my lord.
And the second, A, date and time of arrest, 5/2/20 at 23 p.m.
Yes, ma'am.
23:04.
05 hours.
5 hours. Kindly come to the FIR. What time the FIR was arrested and lodged?
But FIR should be filed after search and seizure
Search and seizure, arrest.
and arrest.
When arrest was made?
Arrest was made on 23
Where, come
5
to
hours, 05 hours.
where is the seizure memo?
Yes, yes.
Where is the seizure memo?
Seizure memo, my lord, 22:05 hours.
Where is that?
My lord, page 18 of their application.
Page 18.
Of the application, my lord. Not in the CD, my lord. CD, my lord. Memo of arrest, my lord. Page 20 in the CD.
Page 20.
Memo of arrest.
No, the
Seizure is 18.
18.
18.
22 5 hours. Yes.
My lord, 22:05 hours to 22:55 hours.
Correct. Yes. Yes. Next, what is your contention?
My lord,
No. What was your contention? Next point you have raised, na?
my lord, the memo of detention, I said.
Where is the memo of detention? Where is memo of detention?
Memo of detention, my lord. My lord, flagged the pages, my lord. The certified copy, pagination is not proper, that is why flagged the some pages, my lord.
Memo of detention is
Time টা কটা ছিল?
Where is the FIR?
Lord, FIR page
2,
1 and 2.
1.
Right.
Memo of detention, memo of arrest, same.
No, my lord, I have seen first time in the NDPS case memo of detention, my lord.
That's
First, memo of detention, memo of arrestation, memo of detention. Detention, there is the memo of arrest. Oh, no. Lot of cases.
আমি দেখি।
what is the time of FIR?
My lord, FIR time
after 12 o'clock, my lord.
0:25.
My lord,
0:25 hours.
0025 hours.
0:25.
On 6th of February 2025.
And when you receive the information?
Receive information, my lord,
When is
At
the
information
15:40
received on,
PM,
but information received on 0025 hours on 6th.
regarding the incident?
Yes, my lord, that is written in the first information report, page 9, kindly see, page 9 of their application, my lord.
Page 9.
Yes, my lord, page 9.
That is FIR.
P1.
FIR.
Yes, my lord, first FIR, my lord.
That is no.
Occurrence of offense, Monday, date
26.
5/2/2025. And next line, my lord, information received date. That is written in 6th of February 2025, 0025 hours.
Seizure memo. So he was detained. He was detained what time? He was detained at 1740 hours.
That is
1940 hours.
1940, that is 7:15. 7:40.
740.
7:40.
And
on
see-
fifth-
on 5th.
On 5th.
When he was how this seizure was made? From where? From the vehicle.
Yes, my lord.
So where is the complaint? What the complaint says?
No. I see that.
page 11, my lord.
From the position of.
Page
From
11.
Page 11 of my application.
Hmm.
Accordingly, the first paragraph.
Hmm.
Accordingly, I, along with the raiding team, headed towards the down bridge, Khoribari PS, Darjeeling, and saw one person and apprehended the same person named above, named Sajjad Alam,
That is
Along with motorcycle.
along with one motorcycle having registration such and such, and one color cardboard
where,
box.
where?
The
But-
first paragraph, my lord, page 11.
Accordingly,
I
along
along.
with the raiding team headed towards so and so. What time?
My lord, the
Local
time is mentioned prior to that page, my lord.
That's why
page-
points. Huh?
Page 10,
Ah,
1920 hours.
1920 hours. We reached at the Singapore near the Dawn Bridge. According, I along with the raiding team headed toward the Dawn Bridge. 1920. Yes. So what is the wrong?
1920, 1940.
What is the wrong?
1940.
My lord, regarding the arrest,
Huh?
the.
What is the wrong?
My lord, the section 36,
Okay.
section 36, see, my lord.
Okay.
And, my lord. I
So
need to
and so
check- yes,
offering for the
my lord,
petitioner.
My lord, kindly, my submissions are not complete, my lord.
So and so offering for the state.
No, no.
My lord, my
Petitioner has
submissions
filed the
are not
present
complete, kindly, my
application
lord.
for grant of bail in connection with in connection with Kharibari Police Station case number 30 of 2025, dated 16 to 2025, for the offence under section 21 within bracket C of the NDPS Act 1985, pending before the Leonard Special Judge Poxo and NDPS Second Court Siliguri. Full stop. The counsel for the petitioner submit that the petitioner was detained by the police on 5th of February 2025 at 1740 hours, and thereafter the police has
Correction, my lord, 1940.
1940 hours, and thereafter the petitioner was arrested by the police on 5/2/2025 at 23:05 hours. The counsel for the petitioner draw the attention of this court to the arrest memo and submit that though the case was initiated on 5th of February 2025, that is after the Bharatiya Nagrik Suraksha Sanhita 2023 was implemented, but still the police has used, the police or NCB police?
Police.
But still the police has used the old arrest memo, wherein there is no clause with regard to reason for arrest. Reasoning ground, where there is no clause with regard to information of grounds of arrest to the accused. Counsel for the petitioner submit that the petitioner was arrested, but no ground was assigned and no information has been supplied to the petitioner why the petitioner has been arrested. Counsel for the petitioner submit that the arrest was made in violation of the provisions of section 36 of the Bharatiya Nagrik Suraksha Sanhita 2023. Full stop. Counsel for the petitioner submit that though the section 15 notice was issued, but in the section notice there is no mentioning at what time the notice was issued to the petitioner.
My lord, in that regard, I would like to place one judgment
To
of
the petitioner. Full
this
stop.
court only.
To the petitioner. Full stop. Counsel for the petitioner further submit that the police of PS Jalpaiguri has not, the police, while arresting the accused and while seizure of the alleged materials, have not followed the procedure. Full stop. Counsel for the petitioner further submit that the seizure was made, the alleged seizure was made on 5th of February 2025, and certificate of correctness was issued on 10th of February 2025. But till date, no CFSL report has been received by the investigating officer, and as such, this violation of Rule 14 of the NDPS Rules 2022. We submit that as per Rule 14, the report has to be submitted by the CFSL within 15 days from the date of receipt of the materials. But in the present case, 2 months have been passed, but till date
3 months, my lord.
Huh?
More than 3 months.
more than 3 months have been passed, but till date no report has been submitted. Full stop. Leonard Counsel for the state submits that the materials seized from the possession of the accused is the
100 bottles.
narcotic, that is the 100 bottle of cough
Cup
syrup,
syrup. 100 ml each. 100 ml each bottle.
which contains 100 ml of each bottle, and as such, the material seized from the accused is a commercial quantity. Police counsel for the petition submit that when the police has received the information, accordingly police has apprehended the petitioner and detained the petitioner. Subsequently, the seizure was made from the possession of the petitioner by following all procedure as provided under law. Police counsel for the prosecution submit that the material was seized on 5th of February 2025, and When the correct certificate of
Certificate of correctness, my lord, 10th of February 2025.
certificate of correctness was received from the London magistrate on 10th of
10th
February
of February.
2025.
And send the
And
sample on next day, 11th.
on the very next day, that is on 11th February 2025, the sample were sent to the
CFSL.
CFSL for examination, but till date the police has not received the CFSL examination, due to which the police has not filed the charge sheet.
Yes.
Police stop. Also for the state further submit that the materials received, material collected by the prosecution find that the prima facie case has been made out against the petitioner, and the material which has been seized in commercial quantity, and the petitioner has not come out with any prima facie case to has not made out any case to come out from section 37 of the NDPS Act. Had the learned counsel for the respective parties peruse the materials on record. This court find that on the information, the police has apprehended the petitioner, and the materials have been seized, alleged to have been seized from the possession of the petitioner. Full stop. After the seizure, the police the same was produced before the magistrate for correctness of the inventory, and after correction of the inventory, the London magistrate issued the certificate of correctness of the inventory, and on the very same day it was sent to the after the receipt of the certificate of inventory, the material was sent to the CFSL, but till date the CFSL authorities failed to provide the report. Full stop. As per Rule 14 of the NDPS rules, the CFSL has to provide CFSL report within 15 days from the date of receipt of the materials. But in the present case, the CFSL has received the materials on 11th of February 2025, but till date the CFSL failed to provide the report to the police authority, due to which the police is not in a position to file the charge sheet. Considering the above, this court find that since the arrest of petitioner is in custody, and due to non-availability of the CFSL report, the police is not able to file the charge sheet, for which the petitioner cannot be detained in custody. Thus, this court is of the opinion that the petitioner has made out a case to come out from the section 37 of the NDPS Act. Accordingly, the petitioner may find bail of rupees 20,000 with two sureties.
180 days does not worry yet, my lord. 180 days does not worry yet, my lord. We are
Whatever, 15 days, you could have, I am not, the charge sheet is not first.
all the CFSL authorities are overburdened, my lord.
Maybe. People, no? Fine bail of 20,000 with two sureties. One surety must be local. One surety must be local with the satisfaction of the learned court. Learned court. So. If on bail, the petitioner shall appear before the investigating officer once in a week, and shall not leave the jurisdictional PS without the leave of the learned trial court. And it shall appear before the learned trial court on each and every date of hearing.
Deeply obliged, my lord. Deeply obliged. I am for the statement.
Yes.
I can say praying for one day.
Huh?
Praying for.
I am rejecting you. Come in the next circuit. Tomorrow is the last date. How the court? Since morning you are taking the only, not today. Then, if you are not ready, why you are coming before the court?
My lord, this is not my personal matter.
So why you are taking the burden of all advocates?
No, my lord, the fact is, my lord, the main conducting advocate has a fixed matter in principal bench, so he told you.
Okay, then let it continue with the principal bench. The circuit bench will be closed. No, I am rejecting you. What is the case? Since morning it is the fourth case you are asked for the adjournment. Then you are the adjournment paid advocate.
No, my lord. Because
Or you have taken the contract of all advocates for take adjournment from the court. So,
the thing is, he has no junior.
that's why you are the contact advocate of all advocates who are not having junior and come before the court and take the adjournment. Poxo.
There was one possible matter also. I don't know if I don't know why they were.
Let me call the password. Let me. Who is for the item number 11? कोई नहीं है, पासओवर मैटर्स कॉल करो, कॉल द पासओवर मैटर्स।
Passover matter, item number 5.
नाम तुम्हारी जावे
That should answer the petitioner. So this was earlier rejected, page 9, NA
पेज 9,
9,
डेड बटर कोडिन,
under bottle coding,
यस।
37, so it was rejected. But the point I am going to raise today was not adjudicated at that point of time. This point is lordship, non-compliance of section 42 NDPS Act. Kindly see lordship, the forwarding report at page 10.
पेज 10,
Page 10. In the middle portion, lordship, starting was submitted written complaint against the accused person with the effect that on 26/4/24 at night at around 20:30 hours, the complainant received the source information that the accused person was coming with cough syrup from Kuzbiak towards Calcutta side on a motorcycle.
on 26 at night at 20:30 hours, complaint is
Complainant received the source information that the accused person was coming with cough syrup from Kuzbiak towards Calcutta side on motorcycle.
correct,
What is lordship?
yes,
Then 26/4/2024 at around 21:05 hours, the complainant and the force started Naka checking. So after receiving of the complaint, it was the mandatory duty of the person received to inform it to the superior under 42(1). Lordship knows better than me. And after completion, after search, seizure and arrest, 42(2), that is, the information has to be given. It was not there. Only what we find here, Lordship, kindly sees in this regard, we have annexed, kindly sees the letter of complaint in page 13, letter of complaint,
page 13,
13.
yes,
The last 4 line of the first paragraph is the same reproduction of that forwarding.
yes,
Accordingly, the fact was diarized, PS DDSA such and such.
correct,
But no communication to the superior was done. Now, whether this diarizing of the information amounts to compliance or not, lordship, we have annex page 23. Kindly please come since page 23. The judgment of Abdul Rakib. The relevant para starts from page 19. If lordship giving pain to lordship, but
para 9,
para 19 lordship.
para 19, page 19,
Para 19, page 5. Page 27. That is internal page 5, our page 27.
page,
Page 27. That is relevant portion. Para 19.
yes,
We are however of the view that a mere GD entry does not amount to due compliance of 42(1). The Bombay High Court in such and such held that an entry taken down in the station diary cannot be treated as information recorded under 42(1) of the Act. The court relied on such and such, also a decision of the Bombay High Court to hold that an entry in the station diary is not due compliance of 42(1) in the DPS Act. Para 20, the second point of the thing is there. Now, para 21. The Supreme Court, however, in Mahavir Singh versus State of Haryana reported and such that the court is forbidden from using the entries of such diaries as evidence against the accused, cannot also be used in any other manner against him. So, this is non-compliance of 42(1). Now, against this order, lordship, the state moved an application SLP before the Supreme Court. Lordship, analysis. Abdul Rakib.
yes,
Delay condon, we are not inclined to interfere with the impugned judgment of the order of the High Court. Accordingly, special petitioner is dismissed. And he says that it shall not hamper the trial. So, the points taken in Abdul Rakib was not overruled by the Supreme Court. So, the non-compliance of 42(1). Now, Lordship knows, I don't think that I have to apprise more that non-compliance of 42(1), as Lordship will find in this, there are several coordinate bench judgments. I have annexed, Lordship, starting from page 31, then 34,
Hmm.
the coordinate benches granted bail on ground of non-compliance of 42.
Hmm.
So I am in custody for 1 year, 26 days and 391 days as of today.
Hmm.
And the charge has not been framed yet.
Why? When the charge sheet was submitted?
Charge sheet was submitted on 4/9/2024.
4/9/2020.
24 and the next date is fixed for framing of charge on 8/7/25.
After the 4/9/2024 till date, what has happened?
Next date is fixed for 8.
After September? After September, it was.
September, Lordship, it has been fixed for framing of charge on 8/7/25. So this year. framing of
After
charge-
September, the case is
Yes,
fixed after.
This is going on.
They have not framed the charge yet. Yes.
I am asking September charge sheet was supplied.
Yes.
Thereafter, how many dates was fixed before the trial court?
Lordship, in that case, we need to
Lordship, the
obtain
last
the certified copy of the order.
The order I am supplying. 8/7/25 for production and charge hearing.
That's correct. 7th May. Then
May.
it prior to, because I am asking with regard to the 30th September till date, how many dates have been?
What has happened, Lordship? Lordship wants to know, Lordship. In that case, we need a complete compilation of the order sheets. Lordship.
Correct. Because the accused cannot take adjournment, accused in custody.
Yes.
So might have the prosecution might have been taken, the adjournment of the court, because kindly come to the 7th May. So and so produced from the so and so accused, file an Ajra on behalf of the accused, the special is present, produce the case record, consider adjourn.
Adjourn for the end of justice.
So maybe Lordship, the court is just adjourning the matter so that because the courts are already overburdened, Lordship. So
why the accused be put in the correctional loan and the correctional loan should be overburdened? If the court is overburdened with the file, why the correctional loan should be overburdened by the publics?
What has
You know how much
What?
amount is to be paid to the each trial persons, under trial persons per day?
391 days, Lordship. Almost 400 days.
September charge sheet supplied. Now July it is fixed about 1 year, charge is not framed. What is the seizure? What is the materials?
Is that 144 bottles, Lordship, but
Huh?
regarding to their contention regarding 42, Lordship, the thing is that in the
No, I am asking what is the seizure? What has been seized
54 bottles.
144 bottle, I'm giving the
of the codeine?
of 40.
Total of
Lordship.
100 ml.
100 ml codeine.
This is the-
Yes. So what is your submission? 42?
Regarding 42, Lordship, regarding 42, Lordship, there was an email sent to the higher authority, Lordship,
Hmm.
but it was complied only on 1st. So after 72 hours, an email was sent. Page number 50 is the Lordship page which has been sent to the
Page?
page 50.
Page 50.
Page 50. That is the seizure, Lordship. Page number 50 is the email which was sent.
Seizure was made 26/4/2024. Correct.
And
The
the-
accused was apprehended.
Yes.
After the apprehended, seizure was made. So the who has come at the time of seizure? Who is the executive magistrate or who is the gazetted officer?
Executive magistrate, Lordship.
So who has informed?
So are you conducting the raid?
Where it is?
Lordship, kindly come to page number 50, Lordship.
50?
Yes, sir, Lordship, be cleared, Lordship.
1st May.
Yes, 50.
5050. This is an email.
Yes,
Seizure on 26/4.
It's the 1st May.
1st May, yes, Lordship. That
Then
is what
please-
they are contending, Lordship.
Ah.
The email, their information was sent prior to 72 hours.
What prior to seizure?
Prior to 72
No,
hours.
Lordship, after 72 hours of the seizure, Lordship.
And
Not
Lordship,
after 72 hours. 26/4
26
May.
Yes, May.
and
4
not-
days.
4 days after.
Not
4
only
days.
that, Lordship, after receiving the complaint, when the matter was diarized, it was the duty of the person to inform the superior that this has happened.
So,
This is the
so how the executive magistrate has come? If you inform the superior officer on 1st May, how the executive magistrate, where is the CD? What the CD says?
In the FIR only, Lordship, it has been stated, Lordship. Kindly come to the FIR.
Yes. Which
At
source?
accordingly, at around 9:45 hours, Sri Anik, WBCS Executive BDO of Calcutta, RF Redasab and anointed him with the entire facts and circumstances, and also requested him for facilitating the search and seizure of the above noted detained motorcycle.
Videography conducted.
Yes. Videography is conducted.
Not mentioned in the FIR, Lordship.
Where is the videography report? If your video was present, you have given the
I've got the statement regarding related to videography, page number,
Lordship, it is not mentioned in the FIR.
page 54.
page 54.
Yes, page 54.
That is Bangla language.
Yes, Bangla language. in that-
But whose statement is this?
The person who has taken the videography, Lordship.
Must take on the video.
Yes.
Lordship, in this regard, neither in the FIR nor in the charge sheet, it has been alleged that the videography was done. So taking a statement subsequently and putting in the case diary, how the prosecution will justify the presence of the person at the point of time. Neither in the FIR nor in the charge sheet.
No, CD is there.
No. What I am saying is not neither in the FIR nor in the charge sheet.
That
It
is,
has been mentioned that the videography was done.
that is.
So if subsequently a
That-
statement of the some videographer is recorded,
No, but the time cannot be adjusted, but the CD is there. India Calcutta received a secret source information. CD is there.
Pen drive is also there.
so my submission is Lordship 42 non-compliance and almost 400 days, 391 days in custody. Charge has not been paid.
Yes, anything?
Lordship, section 37 of the NTPS Act, Lordship, exclusive position from the accused, Lordship.
Correct, but what 7 months, September, now we are, what can be done to that?
No time mentioned in
Your
the 51
prosecutor
video.
is going with the CD and coming back.
No time mentioned in
Where is where is the draft? Where is the draft charge?
21 is there, Lordship. Article 21, I can understand. Article 21, Lordship.
Huh?
Article 21 is there.
No, Article 20, where is the draft charge? What is the duty of the prosecution? On this very day, the draft charge is to be placed before the judge, then the judge has to be, where is the draft charge?
Not there, Lordship.
Lordship, no time mentioned in the section 50 notice given.
So suffering for the petition, so suffering for the prosecution and for the state. Now, the petitioner has filed the present application. Paying for. For bail in connection with Calcutta Police Station case number 180 of 2024, dated 26th of April 2024, under section 21 within bracket C, plus 22 within bracket C of the NDPS Act, pending before the London Special Judge, NDPS Court at Alipur, Dwar. The petitioner submit that. The petitioner submit that. The police, the petitioner was arrested. When he was arrested,
Lordship, he was arrested
on 26th of April,
So there's a
26th of April 2024, on the allegation that on the information received by the police, the petitioner was apprehended and the alleged 140 bottles,
144.
144 bottles of 100 ml each. Codeine was seized from the petitioner. The counsel for the petitioner submitted on the earlier occasion, the petitioner has filed an application for bail, but the same was rejected. Counsel for the petitioner submitted on the earlier occasion when the bail petition was rejected, the petitioner was not placed the point of law which has involved in the matter. Petitioner has not placed the point of law which involved in the present matter. The counsel for the petitioner submit that in the present case, the police have violated the provisions of section 42 of the NDPS Act. 42 of?
NDPS Act, Lordship.
42 of NDPS Act. Police counsel for the petitioner submit that admittedly there is no information in writing was issued by the police authority to the senior officers. It is mentioned in the case diary that a GT entry was recorded, but the recording of GT entry has been deprecated by the division bench of this court in the case of Abdul Rakib versus State of West Bengal, filed in CRM within bracket NDPS 546 of 2023, and the division bench of this court held that entry taken down in the station diary cannot be treated as information recorded under section 42 within bracket 1 of the Act. Counsel for the petition submitted the order of the Honorable Division Bench in the case of Abdul Rakif was challenged before the Honorable Supreme Court, but the Honorable Supreme Court has also dismissed the SLP. Accordingly, the order passed by the Honorable Division Bench has been upheld. Counsel for the petitioner further submits that since the arrest, the petitioner is in custody and police has completed the charge sheet, completed investigation and filed charge sheet, and the copy of the charge sheet was handed over to the petitioner on
Sheet
on
4/9/2024.
4/9/2024 till date, no, fully 4/9/2020. Though the charge sheet has been filed but till date charge has not been framed. Police. Per contra, learned advocate appearing for the state has produced the case diary and submit that the materials seized from the possession of the petitioner is commercial in nature, and the petitioner has not come out of section 37 of the NDPS Act. Full stop. The state has relied upon the email dated 53,
Page 50.
50,
50, yes. sir.
email dated 1st May 2024 and submit that the email was sent to the superior regarding the information of the alleged incident. Police counsel for the state further submit that the alleged seizure was made in presence of the executive magistrate, and as such the seizure cannot be doubted. Police counsel for the petitioner further submit that counsel for the state further submit that the police has complied with all the provisions after the while the police has received the information with regard to the alleged offense, and subsequently the seizure was made and the information given to the senior officer, and after the investigation prima facie case has been found against the petitioner. We submit that so the charge sheet has been filed and the charge sheet has been handed over to the petitioner, and the case will be tried by the trial court. And at this stage, the petitioner is released on bail, from the petitioner will hamper and tamper with the evidence. At the learned counsel for the respective parties for using materials on record. This could find that on 27th of April 2020, 27th, no?
Not 26. 27.
27th of April 2024, the LS seizure was made. But
Seizure 26/4.
no, seizure, what is the seizure, ma'am?
Seizure list
Caesar
page 7.
26/4/24.
26/4.
26/4/24 at 22:05 hours.
What is this seizure, ma'am?
144.
Puff syrup, Lordship, 14 first.
Acha. Seizure was made
Page 17.
made on 26th of 4/2024. But the information to the higher authority under section 42 of the NDPS Act was sent by the police by the investigating officer only on 1st of May 2024, that is after the period of 4 days. After the period of 4 days. This could also find that the seizure was alleged to have been made in presence of the executive magistrate, but neither in the seizure memo nor in the FIR it is mentioned whether any videography was conducted during the seizure. Full stop. The division bench of this court, the prosecution has division bench of this court categorically held that categorically held that an entry taken down in the station diary cannot be treated as information under section 42(1) of the Act. In the present case, though the prosecution has not taken the ground that the GD entry was made, but it is the admitted case of the prosecution that the information was sent to the senior officer only on 1st May 2024, that is after the period of 4 days from the date of the seizure. This court also find that in the month of September 2024, the charge sheet has been supplied and charge sheet is supplied to the petitioner, but till date, the charge has not been framed. The matter was fixed before the trial court on 7th of May 2024. And from the order of the trial court, it reveals that the petitioner was produced from the correctional home, but no charge has been framed, and the learned trial judge has also not assigned as to why the charge has not been framed, and the case was fixed on 8th of July 2025. So considering the above, this court find that in spite of the charge sheet filed by the this court find that the police authority and the office and the information has not been given to the senior officer in compliance of the section 42 of the NDPS Act immediately when they have received the information with regard to the alleged offense, and the said information was issued only sent to the senior officer only after 4 days, that is on 1st of May 2024. Secondly, the charge sheet is filed in the month of September. Charge sheet is submitted in the supplied to the petitioner in the month of September 2024, but till date charge has not been framed. Considering the above, this court finds that the petitioner may find bail of rupees 20,000 with 2 sureties. One must be local. 2 sureties of like amount and 2 sureties of rupees 10,000 each. One must be local, and if on bail, one must be local and with the satisfaction of so. And if on bail, he shall appear before the learned trial court on each and every date of hearing, and he will not hamper and tamper the evidence.
After the statement.
Yes.
Lordship, I am for the petition.
Yes.
Now, in this case, Lordship, I have 3 full submissions.
Yes.
First, this is a case of NDPS, and allegedly,
What is the been seized?
Lordship seized from 2 persons.
What?
Seizure is page 11.
Codeine? No, ganja.
Lordship, 2,160.
Tablets.
2,000
160 capsules.
capsules.
Tramadol.
Thermadol.
Tramadol.
What is the mg?
MG,
Not
Lordship.
mentioned.
What is the mg of the tablet?
Total.
250, 150, 300.
50 commercial quantity of tramadol.
Now that's why what is the quantity? What is the mg?
It's not mentioned, Lordship. Only.
Yes.
Now, Lordship, kindly see page 9 first.
Page 9.
9.
Yes.
That's the letter of complaint. 1, 2, 3, 4, 5, 6. 7th line.
Hmm.
1 nylon plastic bag. Kindly see red, blue, green, and white print. Total length such and such, such and such, such and such. 1 Vivo mobile, 1 folding mobile. So it was 1 nylon plastic bag, red, blue, green, and white. Now allegation is that 2 persons were sitting in the bus stop. Then with this nylon bag. The color is red, blue, green, and white.
Correct.
6. Now kindly comes to page 11, Lordship. That is the seizure list. What has been seized? 90 strips of this tablet, 1 nylon bag, red, blue, green, and white, such and such, mobile. What is Lordship? Now only.
No, 90 strips of so and so.
Ah.
Where is one? Where is a 1 nylon?
The 2, number 2.
1 nylon bag.
Red, blue,
Red,
green,
green, and yes.
yellow. Now kindly comes to page 12.
Yes. Memo of arrest.
memo of arrest. Now, this is the new memo of arrest. Now, may I take your lordship to page 14 directly?
Yes.
Person arrested to be informed of the grounds of arrest and of right to bail. Now, kindly see what were the grounds communicated to me. Please take notice that today on such and such at such and hours, you are arrested by investigating officer such and such in connection with nothing, sent to court.
For the legal action as per law.
What are the grounds of arrest? Nothing. Now, lordship, the question arose whether at the time of first remand, the forwarding report contains the grounds of arrest. May I take your lordship to the forwarding report? The forwarding report, lordship. Lordship, first remand order. She is not able to think of the forwarding report. First remand order.
Yes.
Certificate copy I am giving. Is your document?
Yes, then?
No advocate was appointed. Kindly see lordship, forwarded on 17/8/2024. No advocate, no proof that the grounds of arrest were communicated in the language understood by the accused.
No. Accused so produced, brought under arrest and produced before this court in connection so received accused challan, accused forwarding memo. Yes. Where from you are reading? No.
Accused challan, forwarding,
Correct.
and in below lordship. None moves bail application, no advocate.
The accused person heard in person or heard in person. It already has nothing to say for the police remand.
Remand.
Yes, physically fit.
Now, next order, lordship, 28/24.
Yes.
No advocate appointed. Next order, 23/8/24. No advocate appointed. And only on 3/9/24 the advocate was appointed. Which is a violation of section 304 CRPC and article 39A of the Constitution. Kindly, lordship, may I take lordship to 304 CRPC.
Yes.
Where in a trial before court of sessions, the accused is not represented by a pleader, and where it appears to the court that the accused has not sufficient means to engage a pleader, the court shall assign a pleader for his defense at the expense of the state. Violation. Now, kindly, lordship, may I take your lordship to Article 39, capital A of the Constitution.
The 304 is with regard to the trial.
So I am coming, lordship, with a judgment even at the time of remand, first
So
remand.
that is now the law change. Now, as per the Legal Aid Act, on the very first date of the appearance, the magistrate has to offer to advocate the legal aid panel advocate. He has not been represented.
Lordship. Now this is 39. May I read 39 capital A of the Constitution, lordship? The state shall secure that the operation of legal system promotes justice. What my lord has just now.
Correct. That's why, because
on the basis of equal opportunity, and shall in particular provide free legal aid by suitable legislation or schemes or in any other way to ensure the opportunity for the securing justice.
Correct.
Now, what has fallen from the mouth of my lord is that the advocate of the accused at the first remand from the forwarding report would have seen the ground of arrest. Here, as because no the advocate was appointed and the court failed to comply his job to appoint the advocate, So no grounds of arrest was communicated. And I have mentioned the arrest memo also, where though there is a specific provision and place for grounds of arrest, is conspicuously silent. Now, Lordship, kindly sees. Which para? Lordship, a judgment. Lordship, para 38.2. 38.2 and 38.5. Thirty-eight point two and 38.5.
Let us follow PS.
And 38.5 Lordship from remand.
Then
So I humbly submit that as because there was no lawyer, Lordship, this certified copy I have submitted includes the forwarding report also, which does not speak in that any ground of arrest was at all communicated to the certified copy I have given, Lordship.
yes, from where?
Lordship, may I, Lordship, take the pen? Forwarding table. Lordship, here is the forwarding report.
Yes.
Nowhere it is mentioned that what were the grounds of arrest, and the same were communicated to the accused.
One thing I would say is, since if it is only on the issue of grounds of arrest, then Milord has already reserved orders in a matter. But then Milord, it must be tagged with that matter. If he is pleading other grounds, Milord, then it is a separate thing.
I am
But
pressing,
if it is ground of arrest, Milord, then it has to go.
I am pressing, Lordship, each case has to be dealt with different aspects. Because the factual aspect of this case is not the same.
Cannot be, since the issue of law is
That is
Yes. Next.
because here, Lordship, the grounds of arrest, I have shown, Lordship, that there is a column regarding ground of arrest which is absent. There is nothing regarding this. Lordship, now another is, kindly see the order dated 2/12/2024.
212.
2/12/2024. The order.
Where is here?
Lord,
Certificate copy?
certificate copy. 2/12/2024. Cognizance. Lordship has seen the manner of taking cognizance, which is violative of Rule 183 of Calcutta High Court Subordinate Courts rules.
This is not the revision.
No, but I'm pointing out that
So
there
with
is
regard to
a
if the cognizance is bad, that whether the bail, that is the ground for bail. It is not the.
I'm just placing for the consideration of this is the manner. So since inception, the police in the arrest memo, though there is a provision or there is a column, it is blank. In the forwarding also, no grounds of arrest was mentioned. At the time of first production, no advocate was appointed so that he could have seen the grounds of arrest. Not there. He was taken into custody. It is a sheer violation of Article 22, and Lordship knows that Lordship, particularly one line I want to mention. Lordship knows in Bihan Kumar Lordship, particularly one line, para 13, paragraph 13. Yesterday, my brother made an extensive hearing, so I don't know, do para 13, Lordship.
Yes.
Next page, Lordship. Starts with therefore, as per Article 22(1).
Yes.
1, 2, 3, 4, 5, fifth line. Therefore, it follows that the grounds of arrest must be informed in a language which the arrestee understands.
So that's why if you are totally harping upon the ground of error, then I am keeping your application along with his application so that it can.
Lordship, another is page para 20, can be considered. The duty of the magistrate.
Hmm.
When an arrested person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22(1) has been made. The reason is that due to non-compliance, the arrestee is rendered illegal. Therefore, the arrestee cannot be remanded after the arrest is rendered illegal. So, in my case, Lordship, in the case pleaded by my brother the other day, the advocate was there. The forwarding contained the grounds of arrest. In my case, the arrest memo, though there is a specific column as per the new rule, but it is blank. No grounds of arrest there. The forwarding report, no grounds of arrest mentioned. Not even any advocate was there prior to Lordship 3/9/2024. That is, he was arrested on 16/8/2024 and not prior to 3/9/2024. The advocate
He was arrested on?
written complaint was 16/8/2024. And not prior to 3/9/2024, any advocate was there. So, no scope in this case for knowing the grounds of arrest, which is violation of Article 20.
Note. Yes.
Lord, so far as the issue of granting legal aid advocate to the accused is concerned, my lord, I would say that is not only a settled law, my lord, that is a constitutional safeguard. But not providing legal aid accused does not wipe away the offense. My lord, this does not entitle him to the bail, but I would say, my lord, if an additional sessions judge, my lord, in charge of a special court under the NDPS Act, if not aware of this vital provision for the safeguard of the accused, my lord, he should be sent for training. He should be sent for training, my lord. Because this is something, my lord, which every court has to mandatorily see that whether it has been done or not. My lord, a person is produced in court, he is not provided with a legal aid counsel and the remand application is moved. My lord, this is a serious error, my lord, which requires to be dealt with by this honorable court. And that concerned judge, my lord, should be taken to task. My lord, even a first semester law student is aware that legal aid is, my lord, mandatory constitutional provision which has to be given to everyone. My lord, how come, my lord, a special court judge, my lord, is doing this? And my lord, for that, my lord, the prosecution has to answer before this court.
Yes.
Lordship,
Then
may I interrupt, Lordship? No.
My lord, in that event,
Para 30.
my lord, excellent. In that event, my lord, I have nothing to say on merits. My lord, I leave it to your lordship, my lord, that my lord, sufficient, my lord, reasons must be given, and my lord, action must be taken against the concerned court who has done this. But my lord, that should not be sole ground for bail.
correct.
My lord, another thing, grounds of arrest, my lord, I have nothing to say, my lord, I leave it to your lordship, my lord. It has to, if it only on ground of arrest, my lord, let it be tagged with that matter and let your lordship decide on that. My lord, rest of the things, my lord, the prosecution has
What
able,
is the stage of the trial?
my lord, due for the first witness to be examined.
First, when the date is fixed?
Lordship,
Last date, I think,
16/4 ছিল তারপর
thereafter.
তারপরে নেই
9th June.
June.
9th June.
9 June.
For evidence of CSW 1. CSW Samit Chakravarti is the complainant.
yes
Complete.
yes
He is the complainant, sitting officer.
yes my lord.
Total 40 witnesses.
Huh?
1/4. 14
1/4.
witnesses,
1/4.
including
My
IO.
lord, except this, my lord, all the procedural requirements under the NDPS Act, my lord, has been complied with. My lord, the prosecution, the investigating agency has done the investigation, filed the charge sheet. So, my lord, there is a statutory restriction under section 37. So, my lord, all these things should not vitiate, my lord, the regular part, the investigating part, my lord,
No,
which has been.
only the problem in this case, this is after the new amendment.
Lord,
And the investigating officer have followed the new format.
Lord,
If they followed the new format, so then again the question is whether the new format is mandatory or not. And
My-
the new format they have not given this because it's twofold.
I have seen that, my lord, yes.
Twofold in this because he has issued that format.
Lord,
In the format he has mentioned, but he has not mentioned the reason.
Ground.
One thing. Second thing, if we have not mentioned the matter, so if it's to went to the magistrate has or the session judge or the judge Poxo this NDPS court, he could have been informed. It has also not been informed. Undefended was this. That is the two Distinguish between the.
And Lordship 38.2 says, when an accused is not represented by an advocate, it is the duty of the every public prosecutor to point out to the court.
Yes.
Here the public prosecutor failed to do this.
That is the settled law.
The public prosecutor also failed.
That is a settled. Yes, what can be done?
Lordship knows that, it knows better than me that once it is found that the grounds
No,
are not
Now
communicated.
the problem is that similar issue I kept as
Lordship, every case, Lordship,
that is correct.
in my case, Lordship, I have demonstrated that every latch is on that ground.
Record so and so offering for the petitioner, so and so offering for the state. The petitioner has filed the present application for grant of bail in connection with Madari Hut PS case number 103 of 2024, dated 16th August 2024, under section 21 within bracket C of NDPS Act, pending before the learned special judge NDPS Alipurdwar. Police station. The petitioner has taken the legal issue in the present application is number one, the reason for arrest. Number one, reason for arrest has not been assigned to the petitioner, to the petitioners, though the investigating officer has used the new format in terms of section 36 of the BNNS. Number second, the petitioners were produced before the learned judge on the very first day of remand, and on that day also in the forwarding report there is no mentioning whether the reason for arrest was assigned to the petitioner. And the number three, the learned judge on the date of first production of the petitioners before the learned judge, the petitioners were undefended, and the learned judge has failed to provide the legal aid in accordance with the law. Anything further? These are the 3 points you raised. Police. Consider the learned counsel for the state draw the attention of this court that with regard to giving giving the information to the petitioners / arrestee person with regard to this arrest is pending before this court for adjudication. In view of the above, let this CRM NDPS 153 be kept to the CAV along with CRR number.
CRM number.
CRM Lordship, that was the
CRM number, CRM, that is also CRM number.
Yes, yes.
अरे एक मेरा CAV है ना, तुमको कुछ नहीं, CRM नंबर दे देगा मेरे ऑफिस से, ठीक है? Let them CAV. Hearing concluded, CAV.
grateful Lordship. Deeply obliged.
But 9th June, let us see if today I will complete or not, otherwise we'll see.
But what introduction? I mentioned 25 number item, madam.
Come tomorrow?
But state is also present.
Which one? Who is this for? Give the call the 25.
CRM in UBS 146.
Oh, CRM है ना? 146 of?
CRM in UBS 146.
कौन सा है?
Lordship, this will be a very short submission as because I am not on
On it.
merit.
Yes.
The two accused persons were apprehended, Lordship.
This petitioner, two petitioners, Rupas Tamang and
And there are
cannot
other
capture.
accused persons, Lordship, charge sheet submitted against 3.
Hmm.
Now I take your Lordship to page 24 first.
Hmm. Hmm.
Lordship, against see provisions, Lordship, they were order dated 29 January 2025.
29 or 27 January?
Bottom Lordship, 29 January. Bottom, below the 27 is 29.
Yes.
A petition was served on Andrew Lepcha regarding illness of his father.
No, where is that? The page number 24, no?
Page number 24.
Acha, 29 January.
29 January.
Yes. Record is put up, praying for a release on bail, copy petition served. What is the ground?
His father was ill and interim bail was granted. Now, Lordship, I am handing over.
Where is the interim bail?
Interim bail, Lordship.
Order?
The same order.
Therefore, the
25,
accused
26.
Andrew Lepcha may find bail of rupees furnishing 10,000 with his registered sureties. He is subject to the satisfaction of CGM Kalimpong. Yes, then?
Lordship, I am submitting certain documents where the mother of the lecture, that is Nicanor Lepcha. Mother is suffering from CA rectum.
Second petitioner. Second
petitioner, Nicanor Lepcha is suffering from CA rectum. Her name is
Pain
Lepcha.
Pain abdomen.
CA rectum.
CA rectum.
And the documents are there.
What is it? Admitted 13 January 2024.
Lordship.
Then?
And the other treatment documents are there. She, as per my instruction, Lordship, she requests to be.
When the application, the 29 January 2024, why this petitioner was why this petitioner has not filed the application before the London judge?
Lordship, he filed it.
Where it is? Where his application?
Lordship, last order 22/4/2025.
22/4/2025.
He prayed for bail.
No, with regard to the you have taken the medical ground. Where is that?
Medical ground.
22/4. Where is the order?
The order. Lordship, 22/4/2025. That is order number 25.
Where is that?
Certified copy, Lordship. Last page.
Certified copy.
Lordship.
Yes.
The order does not speak regarding the same.
Correct. You go file before that NDPS code. These are 24, 22 to 4. You are not disclosed this document before the magistrate judge.
As per the order, yes, Lordship.
Correct.
The Lordship, liberty may be granted to place this before the judge.
So suffering for the petitioners. So suffering for the state. The petitioner has filed the present application for grant of bail in connection with Kalimpong Police Station case number 112 of 2024, dated 4th September 2024, under section 21 within bracket C/29 of the NDPS Act 1985, pending before the learned special judge NDPS Kalimpong. Counsel for the petitioner has drawn the attention of this court to the order dated 29th of January 2025, wherein one of the co-accused, namely Andrew Lepcha, ANDREW, Andrew LEPCHS, Lepcha, had filed an application for bail on the ground of the treatment of his father. And accordingly, the learned trial court, being satisfied with the document, has allowed the accused Andrew Lepcha to go. This is not interim bail.
Bail.
Has क्या बोला? Andrew Lepcha has granted bail. Full stop. Now the petitioner has filed the present application and produced the document. Now the petitioner has drawn the attention of this court to the medical treatment documents of one. What is the name of one Srimati or Siri?
Srimati.
Of one Srimati
Srimati
LIKIT. Likit Lopcha. LOPCH Lopcha. Mother of the petitioner.
Number 2.
mother of the petitioner number 2, namely Nicanor, Nikanor, Nicanor Lepcha, and submit that his mother is also suffering from this CS rectum and correct, and is and she is and the mother of the petitioner is continuous under medical treatment. He prays for the similar order as granted by the learned trial judge to Mr. Andrew Lepcha. Police counsel for the petitioner had drawn the attention of this court to the order dated 22/4/2025, wherein the learned trial court has rejected the application of the present petitioner, namely Andrew Lepcha. No, present petitioner, namely Nikonar Lepcha. But this court, after going through the order dated 22/4/2025, this court find that the petitioner has not taken the ground of the illness and treatment of the mother of the petitioner, Nicanor Mecha. And thus the learned trial judge has no opportunity to go through the document relied by the petitioner. In view of the above, this court is of the view, instead of going through the said document, the petitioner, the present application dismissed with the liberty to the petitioner to approach before the trial court for grant of bail by relying upon the document of the mother, document of the treatment of the mother, and if any application is filed by the petitioner Nicanor Lepcha before the trial court can consider it in accordance with law and pass appropriate order.
Grateful.
CRM so dismiss बोल दिया ना. Next, call the.
Lordship on indulgence, Lordship, today morning I have mentioned one matter, I just got 21.
Ah.
It was running this.
Yes.
So kindly that matter will be taken up.
Come tomorrow. Come tomorrow. What is the matter?
My lord, in this case, my lord, all total 560 grams of morphine was recovered from the joint possession of two persons. One of the accused person was granted by your lordship on 15/5/2025. As there is a violation of section 52A of the NDPS Act, I stand on the same thing, my lord.
Come tomorrow. इसको कल रख दो list में.
My lord, I have a matter in the lower court tomorrow. I maybe.
So what can be done? Either you appear before the lower court, because I cannot go beyond this. But I have 40 minutes over. As per my determination, I cannot take, madam. Come tomorrow. Yes, 21 तारीख को कल रख देना. 21 नंबर को कल रख देना. Yes, call the matter. क्या हुआ? क्या हुआ? प्रॉब्लम क्या है? 12 बज गया ना? 12 बजा नहीं बजा? Go by the list. Yes, 61.
So this is application for extension of interim order, madam. The interim order was initially granted on 29th of January, madam. For a.
Have you served the copy?
Yes, ma'am. But the copy of the opposite party number 2 has returned with the endorsement not known, madam.
Opposite party number 2.
Yes, sir.
Who is it?
Of the same.
Who is he? Opposite
The
party.
complainant, ma'am.
Huh?
The complainant.
De facto complainant. What is the case?
The case is under section 426, 409, 422, particular of the Indian Penal Code. But the complainant.
So what application you filed?
406.
No, what?
Extension.
Where is the interim order?
Well, the interim order was initially granted on 29th of January, for a period of 6 weeks. And on the date of expiry, the application was preferred.
29th of January?
Yes, sir.
Where is that order?
City organizer.
27 January. Accordingly, there will be stay of the CR case number.
Yes, my lord, see, a private.
Yeah, absolutely civil in nature, my lord can get out the matter also, not medical. Absolutely civil in nature now.
I am overburdened.
So can you see the complaint for once? My lord, won't need anything else to see. The defective complainant entered into an agreement with the landowner. Subsequently, he came and paid an amount of rupees 10 lakh, although that amount was.
Okay, I am extending the interim order. So suffering for the petitioner, so suffering for the estate. Who is for the complainant? Nobody.
Nobody.
None appears on behalf of the opposite party number 2. Opposite party number 2. Police. Any opposite party number? Opposite. Who is the opposite party number?
Complainant. Defective.
2. None appears on behalf of the opposite party. Affidavit of service filed by the petitioner has filed the supplementary affidavit disclosing the documents and also filed the affidavit of service wherein it found that the service could not be affected upon the opposite party number 2. Police counsel for the petition. The petitioner has filed an application being CRAN number 1 of 2025, praying for extension of the interim order dated 27th of January 2025. Consider the submission made by the counsel for the respective parties. This could find that the service could not be affected upon the opposite party number 2. Accordingly, the petition is directed to take appropriate steps for service of notice upon the opposite party number 2. In the meantime, the interim order granted earlier is extended for a further period of 6 weeks from date. Police. Or until further order, whichever is earlier. CRAN number 1 of 2025 is disposed of. And let the matter appear before the next circuit.
Item number 62.
Yes. What is the revision? What is the CRAN? What is the CRAN?
I'm praying for next.
Huh?
I'm praying for next, sir.
Not today.
Next, sir.
What is the matter?
State mother.
What is the matter? Yesterday matter?
No, sir. No,
Ah.
sir. The extension of it.
When the interim order was passed?
Extension may be disposed of, my lord.
15th of February for 2 months.
2 months. So April it was over. April it was over.
Yes, extension application.
When you filed the extension application?
23rd of April, copy, notice was served.
10th April you filed. Who is both the party appearing?
No, sir, last occasion the opposite party number 2 appeared today.
Today not appearing. So and so appearing for the petitioner, so and so appearing for the estate. None appears on behalf of the opposite party number 2. The petitioner has filed the present application being CRAN number 1 of 2025, praying for extension of the interim order dated 18th February 2025. Counsel for the estates. The counsel for the estates only on when you received the copy, 19th April.
We have received it on 23rd of April.
Only 23rd of April 2025, that is after the expiry of the interim order. Consider the submission made by the counsel for the petitioner. This court, due to paucity of time, the original application filed by the petitioner could not be taken up for hearing. Accordingly, the interim order granted earlier is extended for a further period of 6 weeks from date. Police. Let the CRAN number 1 of 2020 disposed of. Please the matter before the next circuit bench.
Item number 63.
I'm for the state, my lord.
I'm for the petitioner number 2.
Yes.
So the extension of interim order, interim order was granted on 12th of March 2025 for 8 weeks.
March, 8 weeks.
Application was filed on 29th of April.
Yes.
Lordships, CD is recorded, lordships, the Batigara PS case number there.
City is there.
No, lordships, CD is recorded.
so suffering for the petitioner, so suffering for the state. None appears. Who is for the opposite parties?
Lordship, opposite party was failed, but it was redirected as insufficient evidence, so.
None appears on behalf of the opposite party. Number two. Counsel for the petition has filed affidavit of service, which shows that the affidavit and the notice could not be served upon the opposite party. Accordingly, petition directed to take appropriate service of notice upon the opposite party number two, and to file affidavit of service on the next date fixed. The petition has filed the present application being CRAN number 1 of 2025, praying for extension of the interim order granted by an order dated 12th of March 2025. Consider the submission in full stop. Consider the submission made by the counsel for the respective parties. Due to paucity of time, the revision application would not be taken up earlier. Accordingly, interim order granted earlier is extended for a further period of 6 weeks from date.
Lordship, CD may kindly be called for.
Date. Release the matter before the next circuit bench. The state is directed to produce the CD on the. Now, let us see the other judge will come then.
Lordship.
Place before the next circuit bench. Next.
Item number 64.
Led
Led by Mr. Ajay Singh.
my lord order has been complied with, my lord. Reason order has been passed.
Contempt application.
Yes, my lord.
Appealing for the arrest contempt number 2, he is appealing for the arrest contempt number 1.
My lord, I am appealing for the petition,
copy
my
of the-
lord.
Okay.
A copy of
My
the
lord, the
order has also been
order
sent
has
out
been
to the-
passed, but my lord, it's not in compliance to my lord's direction, my lord.
Yes, who is part of petitioner?
Appointment. My lord, I am for the petitioner, my lord. My lord, kindly seize the order passed by the.
Now, my lord, this is
My lord,
beyond
kindly
the
seize
scope.
the order passed by
of the
the commissioner.
Where is the
My lord, it has
affidavit of
not been passed.
compliance? Where is the affidavit of compliance? Let the contender appear in person. This is the way. You have not gone through the last order. Playing with the court. After the 1 year, you are coming with the compliance order without any affidavit. So and so appearing for the petitioner, so and so appearing for the alleged contemners. The petitioner has filed the present application on the allegation that the order passed on the allegation that the alleged contemners are not complied with the order passed by this court. The matter was taken up for hearing on the last date. Kya date tha? On the last date, and this and before the on the last date of the order. The matter was taken up for hearing by this court on 20th May
15th May.
2025.
20th May.
20th May
15th
2025.
May, my lord.
20th May 2025. 25, wherein the learned advocate appearing for the alleged contender submit that they will issue the reason order in course of the day and will file affidavit of compliance. Accordingly, on the submission made by the counsel for the alleged contender, the case is fixed today for filing of compliance report, affidavit of compliance. But when the case is called today, no affidavit is filed showing the compliance. Accordingly, the alleged contenders are directed to appear before this court in person tomorrow at 10:30 a.m.
Deeply obliged.
Number 66 for the petition of
The बच्चा वो अभी जो ऑर्डर किया ना उसको जल्दी अप्लाई कर लो उसको कम्युनिकेट करनी द रजिस्टर इज डायरेक्टेड टू communicate this order to the alleged contempt.
There are several rounds of litigation between the petitioner and the bank authority. There is an allegation of the fraud by the bank authority. There the FIR was filed, investigation was conducted, charge sheet was submitted. After filing of the charge sheet, bank came before this honorable court for question of the that proceedings was contested, though the FIR was not quashed, the honorable court was direct to the IO to apply for the sanction before the appropriate authority of the day.
Sanction
Sanction for prosecution.
197.
Because the appropriate authority.
This is the IPC section or POC?
IPC.
IPC, yes.
And that was applied for by the investigation officer and the sanction was refused. It was before
Sanction was refused by whom?
by the authority of the bank. Bank of it. And it was form of supplementary charge sheet. It was filed for the London court. The defective complainant applied for a copy of the charge sheet along with the supplementary charge sheet. Everything is given, but that refusal of sanction has not been given. And we make an application before the London court below for the prayer to give the copy. That has been refused. Our humble prayer is to give a copy of the supplementary charge sheet, where the copy of the refusal also ends.
What your challenge here? What order your challenge before this court under the revisional application?
Order case is 19, December 2024. The certified copy of the order is with the original application. I will kindly see the last.
Direction to prosecute in reference to the proceeding of delegated person. Where is the order?
That's fourth page. There's certified copy.
Yes.
Order dated 19th of December 2024. The application is wait for supply copy of someone's report as
19 December. This is application.
Last one is my application. Before that, there is an order dated 19th December 2024.
Correct.
My lord, it appears the IO report has submitted a supplementary charge sheet after obtaining necessary sanction from the bank authority. There is no provision to supply as a copy of the sanction order to the de facto court.
Sanction is received.
No, that is received before the landed court below.
Sanction was granted.
No, the sanction was refused. That order was received in a form of supplementary charge sheet by the investigating authority. And that was submitted before the landed court below. We have given the copy of the charge sheet.
Who are you?
I am the de facto complainant.
The complaint case?
Yes, sir.
Sanction.
This is a case, police case.
GR case, my lord.
GR case.
Yes, but we are the de facto complainant.
Correct.
But there is also a separate complaint case also there. But it is not required.
This case is initiated, this application filed by whom?
By me.
How?
Because
How you can go directly? Have you taken the leave from the court?
no,
You being the de facto complainant has been given the public prosecutor or the assistant public prosecutor, whatever it may be. Have you taken leave to, you have to appear before the public prosecutor appear in person along with the public prosecutor, or the public prosecutor given you leave to appear? So how you can override the prosecution?
From the earlier official, it was asked to us that whether we applied for certificate copy of that.
So that's why you could have been,
That's it.
sir, you are the de facto complainant. You have been represented by the APP, appointed by the government, because it is the district judiciary. District judiciary, all the PP has been appointed by the government, and he has been taking care of the case of the complainant as a state case. So you want this document have been come to the APP or public prosecutor, whatever it may be, so you can get the copy from the APP.
no, my lord, that has to be, my lord.
Have you approached the PP?
We applied for court. We applied.
You can't approach the court without the leave.
I have been given the audience, my lord, because
You have given the audience, but that is suffice to you your purpose. But how you can without the leave of the court?
because there is an order dated 18th July 2024. I am just reading one line, my lord. Landed advocate for the de facto complaint.
Sir, I am only asking. This is not a complaint case. This is the GR case. GR case has been represented by the PP. Or no, sorry, in the lower court it is the APP. But it is the APP. It is the APP. Correct. So where is the application for the APP for supply of the copy?
Opposite our plan. It
Yes,
is the opposite our
that is recorded there. That is opposed.
our interest is in Under consideration, our interest in effective, sanction not given by the authority concerned. We apply for copy of that so that we can take recourse against that not
You can
granting sanction.
take the
But
steps.
we have not given the copy.
My lord, if
On
you-
the earlier option, lordship, supplementary given to every given to.
So this petition, this accused persons are the bank official. And who are you?
I am the defector.
Who are you?
Hold. My property has been taken over by the bank by filing false documents. That's my sanction.
That's why sanction is not given.
No.
Okay.
Lordship, private, supplementary pin number is.
So issue notice.
No, not
Serve
required.
notice.
My lord, if there is any IPC section, sanction is not required, my lord.
No,
As per Bakchi's order, my lord,
no, 197 is the government official permit.
No.
my lord, but if he is involved, directly involved on this case, my lord,
Correct. So that is
until or unless that should be ascertained, my lord. They
But-
never
but
given
the
sanction, my lord.
that's why, but the learned CGM has not passed that order.
My lord.
My-
That is the
Yes.
That's why
that is the
after
impute portion, my lord.
after
Yes.
going to this, the London magistrate has passed, he is not entitled.
My lord.
The London magistrate not passed an order.
My lord.
Without the sanction, he will proceed. And he has stated that the final report, filing
My-
final report.
Yes.
That cannot,
My lord. My
that
lord.
cannot be. So and so appearing for the petitioner. The petitioner has filed the present application challenging the order passed by the ACJM Siliguri. Siliguri in GR dated 19/12/2024 in GR case number 2127 of 2018, wherein the prayer made by the petitioner being the de facto complainant for supply of refusal of the sanction order to the accused is been refused. Police, this would find that the petitioner has made out an arguable case and is to be heard in presence of the opposite party. Accordingly, the petition is directed to serve the copy to the opposite parties, to the opposite parties, and to file the affidavit of service on the next date fixed. Release the matter before the next date fixed. Yes, any urgent matter?
Lordship, supplementary,
Supplementary affidavit filed by the petition be kept in the record. ठीक है जी?
My lord would be pleased to take up item 102, my lord. It had been mentioned in the morning.
My lord.
Not
My lord-
uploaded in presence of you, in your presence the court was passed. And you have taken
দাদা,
100.
বলো দাদা আমারটা শুনতে পাচ্ছি।
Let come.
My lord,
Not go with the sue of the client, sir.
My lord,
একবার বলো। আমারটা শুনতে পাচ্ছি না।
Let they come.
Lord, item number 78. Lord, that is a very urgent matter.
Tension
Relating
is
to the
going on.
right to fair trial of an accused person, Lord.
Huh?
Right to fair trial of an accused person who is facing charges under the Poxo Act. Lord, very urgent, Lord, because the trial court will proceed, Lord. I'm upping on an interim order. Lord, I will not take more than 10 minutes, Lord. That much I can assure your Lordship, Lord. And that is in motion matter, my Lord. Only motion matter, so no difficulty. 10 minutes time, if spared, my Lord, that can be done. 78. 78, my Lord.
My lord,
78.
Yes.
102 of it is this, my lord.
What is the 60? What is the 67?
Order.
67. Yes. Yes, your matter is?
My lord, 102 of it, my lord's list, my lord.
102. 102.
Lordships.
See. 67. Record. 67, 78, 101, 102. After lunch, हम लेंगे. After lunch.
Deeply obliged.
I'll
Deeply
upload the
obliged.
format library.
Lordship. My lord 73 also, my lord, there's some urgency, my lord.
Grateful, my Lord, grateful.
My lord 73 also, new motion, I'll take 2 minutes, my lord.
73 भी रख देना.
My lord. Grateful, my lord.
Grateful.
কোন নাম্বার গুলো বলেন তো একটু? বলেন 67 73
হ্যাঁ
78 101 সব কটাতে আমি আছি 101 102 101 আর 102 ঠিক আছে
কে আসে পেন করে আর
একটা সময় মানে এখন ভাবতে পারছি কোটি কোটি টাকা দিল আমরা তো কোনো বিক্রয় আমাদের বিক্রয় আমি
এরাও আছে এরকমই কিছুই বলে আজ একটা বিয়া একই তো মিটিং করছি না মিটিং গুলো করতে হবে কি আপনি
কাজে সুবিধার জন্য এগুলো আমার লিখে দেখো
No, further, yes.
Milord, one matter, Milord, 106.
Not at this as no mentioning, whatever I have taken already. Sorry. Which one? Okay, we'll see to that. Yes, call the list, call the. Item number?
Last petition, Lord was liberty, file supplementary affidavit, along with the petition, copy of the petition, copy of the WO, the copy of the deposit. This is a supplementary affidavit.
Who is for the opposite party? Motion is.
Joseph Joseph candidature, out of page number 15, line number 13.
50?
15, 1 5. Line number 13 of my supplementary evidence.
15.
15, supplementary evidence.
Yes. Supplementary affidavit. Where is the supplementary affidavit?
That is my.
अरे यहाँ लेके रख देता.
No. 125.
Yes.
Page number 15, my lord, line number 13. I have not filed any asset declaration before this court. We have raised that point before the.
Page number 15.
Page number 15. Line number 13.
I have not filed any.
Asset declaration before this court.
And
that is my only contention, my lord. That without having the assets and liabilities declaration, the trial court was pleased to pass an order. Though, my lord, can you see the page number 12, my lord? From the bottom line, line number 3. It is fact that at the time of marriage, I was employed and self-dependent. She is a school teacher. And she paid for maintenance. And her husband is an LIC agent.
So, at the time of evidence, have you adduced the evidence?
My lord, that is page number 12. Page number 12, line number.
This is the cross-examination.
Cross-examination.
You have adduced your evidence.
No, my lord.
So, if you are not adduced evidence, you have taken the plea that the wife is working and wife is earning the amount. So, it is your duty to prove the case to bring it.
She admitted.
What admitted?
That
Where
I
is that?
was self-employed.
I was self-employed. Was and is.
My lord.
Present tense, past tense.
Can you see, my lord? Till now she is working, my lord.
That's why if it is your case that she was working, she was earning, but she has suppressed the fact and obtained the order, but you have to prove where is your evidence that you have called for the record from the authority and you have produced the pay slip or what or the income slip, whatever it may be, to show that your wife is working and
She admitted in his cause.
Where is the admission?
Page number 12.
Page number 12, I am there.
Page number 12, first, I am a teacher of Bengali subject.
Where it is?
That is.
I am a teacher of Bengali subject. So where is the amount amount salary?
Salary, my lord, she stated.
Where is the salary? What amount she was getting monthly?
He stated that I have earned 12,000 per month.
Where is that?
Lord, I am.
Show me.
My lord,
At the page number 11.
Page number
11.
11.
11.
Yes.
Cross-examination from the bottom line,
Hmm.
line number 4.
I am drawing monthly salary of 12,000 after deducting EPF for the last 2 months, and before this I was drawing monthly salary of 11,000 after deducting years. So
madam, she is an earning lady. Now,
what amount has been passed by the London?
5,000.
Where is that?
Madam, that is the order.
Where is the finding of the London magistrate?
That is the
Where is the impugned order?
impugned order passed by the judicial magistrate, third court, my lord.
Where is the order?
My lord, page number 3, my lord.
Page number 3 of
3 of the order impugned passed by the
supplementary.
My lord.
Supplementary.
No, my lord. In the main petition.
Main petition.
In the certified copy,
Ah.
page number 3, second line, second paragraph.
Page number 3. Yes. After hearing both the parties, London trial magistrate has passed the impugned order whereby the London magistrate allowed the prayer of the 125 5,000 permanent to the petitioner as monthly maintenance. Yes. Where is the magistrate order? Not enclosed. Ah.
Oh, my lord. Page number 12.
Page number
12.
12.
12 and onward.
12 onwards. After carefully scrutiny of the evidence, petitioner and other material, the opinion has been able to substantiate contention. The petition has left the matrimonial laws voluntarily and has sufficient source of income. Has not able to substantiate his contention, sufficient income. Well, she's alone.
She is alone. No issue.
No issue.
No issue. Two faults I have, my lord. Number 1, no asset declaration was.
Where is your evidence?
My lord, my evidence was not on it.
What is your salary?
I am a LIC agent, my lord.
Correct. What you
10 to 12,000.
How she has proved your income?
10 to 12,000.
How she has proved your income? Which?
Through a PW2, my lord. Sufficient evidence.
PW2.
PW2.
Page.
Page, my lord, 17.
I have filed the return affidavit, census. Today I filed the computer generated document. I have filed the authorization. I have extract the agency earnings. What is exhibit 3?
Exhibit 3, that is our a commission statement.
Where is that?
That was not in annexed.
I have filed the extract of the agency earning the financial. What is the financial capacity? That is exhibit 3.
Hello.
Where is that?
That is not annexed.
You are not having the copy of with you in your file.
No, my lord, they did not file any. Why any copy to us?
How this document has been dealt by magistrate? How this exhibit 3 dealt by magistrate? Where is that?
My lord, Madam, can you see the page number 20? The main petition.
Instead of the OP is able body and staying census and pointed to petition able to prove the LIC agent and handsome income. Other than it,
No asset declaration was filed, my lord.
Where is your evidence? You are not adduced the evidence. What
No,
the
my lord,
magistrate? What so?
My lord, I have not been permitted to adduce evidence.
Why?
I was applied before the London trial court, and the London trial court was pleased to observe
that the evidence was closed.
Correct. So why you are not appeared before the magistrate? You
I-
appeared,
I
you
have-
are cross-examined, so why
No.
you not reduce the evidence?
But I am not permitted to do so.
How it can be said? Where is the order? Closing your evidence.
That is no order.
Sorry, 5,000 rupees, you are not reduced the evidence?
But no asset declaration was passed.
Might be, where is the written objection? Where is the cross-examination? There's a declaration, where is the cross-examination?
It's already said.
Where is in the, kindly come to the page 17?
My lord, kindly see the page number 15, my lord, supplementary affidavit. Line number 13. In the cross examination.
I have not filed the asset declaration. Correct. So, where is your asset?
I have already declared.
Where is that your
That is
asset?
supplementary.
So,
Page number 18.
page number?
18.
Deposit in bank 11,000. Bike 4,000 per month. Gold ornament 30,000. Where is the monthly income?
Monthly income, my lord, 7 to 8,000 per month.
Where you mentioned?
That is not in the format of the declaration of assets and liabilities, my lord. So I cannot mention. Which I have filed for the land trial court. I have filed for this land
So
trial.
that's why you are not brought the exhibit 3. What is your, because the LIC persons have brought that exhibit 3. What is the exhibit 3?
Exhibit 3, they say commission statement. Commission statement.
That's why how much you got, that is the thing is to be seen.
That order, that copy was not supplied to us.
So what you want now?
Now, my lord, the matter may be stayed and the
no, it's taken not 5,000 rupees. Sorry.
my lord, as an LIC agent, she is an independent.
Okay, let you argue the matter on merit. So and so suffering for the petitioner. The petitioner has filed the present revisional application challenging the order passed by the learned Judicial Magistrate Third Court, Jalpaiguri, dated Jalpaiguri dated date 27th of February 27, 2024, wherein the London magistrate has passed an order directing the petitioner husband to pay rupees 5,000 per month, being the monthly maintenance of the opposite party to the opposite party number 2. To the opposite party number 2. One. To the opposite party number 1. As well as the litigation cost at the rupees 5,000 per month. 5,000. Litigation cost of rupees 5,000. The petitioner, being agreed with this order, has filed an criminal division before the London Court of Sessions Judge Jalpaiguri, being criminal division number 15 of 2024. The London Sessions Judge Jalpaiguri has dismissed the appeal by affirming the order passed by the London magistrate on 8th of April 2020. Full story. This court find that the application is to be heard only after issuance of notice to the opposite parties. That the petition directed to serve the notice upon the opposite parties and to file affidavit of service on the next date fix. Release the matter before the next circuit.
Grateful.
Next.
Item number 73.
Please, Your Lordship, I am appearing for the petitioner on the virtual mode. Well, am I audible to Your Lordship?
Yes.
Yes. Well, if my learned junior friend over there can hand over the list of dates which has been prepared to Your Lordship.
Have you saw the copy?
No, my lord, it's at the stage of motion.
Yes. Yes. What is the order? What you are challenged?
I am challenging the proceeding itself, my lord. a case has been started against me under section 316 subsection 2 and 316 subsection 5 of the BNS. My lord, that corresponds to 406 and 409 of the Indian Penal Code.
Yes.
Now, my lord, in the year 2018, my lord, Union Bank of India had issued a e-auction sale notice. My lord, that is at page 27, if I may draw your lordship's attention. And in the meantime, if my learned junior friend can hand over the list of dates, please.
You will not find that type of the junior which you are getting in Calcutta.
Lack of
After your argument, the junior will come.
Sorry, no. Anyway, what to say? Well, but your lordship will kindly take up page 27. My lord, on the left bottom,
yes,
this is the auction notice, and in the schedule, my lord, your lordship will find number 5 and 6 were the properties which we had purchased. My lord, 5 was a freehold property, and 6 is the property in dispute.
Land comprising area 1019 square feet.
Yes, well, that is not in dispute. This is a freehold property. This is never in dispute.
Correct.
Next one is the issue. Is the land in issue?
Which one?
Land measuring 1170 square feet, having at present 1000 square feet, built on municipal holding number 8 and 9. This in Darjeeling. Well, on the basis thereof, we became the successful bidder. And thereafter, sale certificate was also handed over. Well, that is at page 28, the very next page.
Yes.
The undersigned being the authorized officer of Union Bank of India under securities in exercise of powers, rules, Darjeeling Bank, sold on behalf of Darjeeling Bank, Union Bank of India, Darjeeling branch, in favor of Sri Vimal Jawar, Sri Pradeep Ojha, and Praveen Agarwal. They are the petitioners before your lordship. And the immovable property shown in the schedule below, secured in favor of this by late Sri Naval Kishore Soni, and then the other names, towards the financial facility of cash credit limit of 7 crores availed by Messrs United Corporation. The undersigned acknowledge the receipt of the sale price of rupees 1,53,85,000 in full. And this is the next part is very important, my lord, if your lordship kindly notes it. And handed over the delivery and possession of the scheduled property.
Yes.
Then kindly sees the sale of the scheduled property was made free from all encumbrances known to the secured creditor on deposit of the money demanded by the undersigned. Now here also, number 2 is the land which is in question. Now this land had a pre-existing lease of the Darjeeling municipality.
Correct.
Well, then we wrote in 2022 to the Darjeeling municipality asking for issuance of fresh lease. That is at page 36. Page 36, my lord.
Yes.
My lord, will kindly see the 3 are there: Bimal Jawar, Praveen Agarwal, Pradeep Ojha at the bottom. This has reference to land schedule to this, and we have mentioned about the municipal plots, and the municipal holding is 8 and 9. Your lordship will find municipal holding is 8 and 9, as stated in that.
Yes.
Total area 4.1170 square feet. Your lordship will get.
Yes.
Is under possession. The above land was put on auction by the Union Bank of India, Darjeeling branch, and we, the undersigned, were the successful bidder of the auction.
Correct.
And we have annexed the sale certificate. Thus, we request your good self to issue fresh lease in the name of then the 3 persons who were there. It was already a land with pre-existing lease which had expired, given by the Darjeeling municipality. Well, then we had annexed also the plan at 37.
Yes.
The sale certificate at page 38.
Yes.
and 39, 40 are more cleaner copies. 41 is important.
Yes.
We deposited a sum of rupees 2 lakhs. My lord kindly sees on account of fresh lease fee.
Correct.
Thereafter, a lease, purported lease, I will not be, I know your lordship is quite adept in this side also, both in the criminal side and the civil. My lord, a lease, purported lease was executed in our favor by the Darjeeling municipality, because this was not a registered document. It
Yes.
was for a period of 15 years, but was not, it's at page 42. I'm
Yes.
sorry.
Yes, yes, got it.
Yes.
So why you're not gone for the stamping?
Malad, yes, we have not gone. Now, there are, before that, Malad, this happens on the 20th of November 2022. Kindly
Correct.
see the date.
Yes, yes.
Now, because there was a change now in the control, Malad, an FIR has thereafter been lodged against us and the then chairman of Darjeeling municipality, alleging commission of offences under section 406, 409.
Where is the FIR?
Well, the FIR is at page 20, the letter of complaint.
Yes. Who has given this?
Malad?
Complainant.
Yes, he is the chairman.
Chairman.
He is presently now in control of the board. And the third and the other accused person is also the former chairman, Ritesh Potel.
So this.
Now, in short, the allegation is that the land is valued at 1.5 crores. And without taking into consideration the monetary value of the land, it has been given by way of a lease to these persons in an illegal manner.
Yes.
Yes, Malik. Now, if I may only request my learned junior to hand over the copy of the Registration Act.
So now what you want now?
Well, I want a stay of the proceeding. 406, 409 is not maintainable against me on 2 counts. Well, first of all, the municipality has not handed over possession to me. So there is no entrustment by them and consequent misappropriation by me. My lord has seen this was already in the possession of the erstwhile leaseholder, then in the possession of the bank, and bank has handed it over to me. That is not in dispute. So they had never entrusted this.
Not the property is with whom?
Property is still with me. I am the possessor of the land. Yes, my lord.
You occupied the property.
Occupation. Yes, my lord.
Okay.
Now, therefore, kindly see if at all I am a.
Have you transferred the ownership? No, nothing.
Well, it's a leasehold property. It's the owner is the municipality. I am in possession.
So you're not interested to any third party.
No.
To any third party.
No. I am possessing it since 2020.
That
2019, my lord.
Okay.
And this case is being started in 2025. I have not done nothing. Now, kindly see section 17.
Charge sheet filed?
No, my lord.
When the FIR was lodged?
Well, FIR was lodged 30th of April.
30th April this year?
Yes, my lord.
5. Have been arrested? Have you got the bail?
No, I have not been arrested. I have come before your lordship for protection. Well, at 406, 409 is not made out in this case.
Yes, what section you want to show?
Yes, my lord, section 17, if your lordship kindly sees.
Hmm.
17(1)(d). So any lease above 1 year, it is compulsorily registrable.
Correct.
I have not taken any steps on that also. Now, if that goes away, if assuming that it's an unregistered document, if that goes away, then the only thing that remains in this case is that I am an illegal occupier. Now, for that, they have to take relevant requisite steps. I cannot be ousted except by due process of law. I have paid money to the bank against that.
Yes.
Now they are trying to arm twist and initiate any proceeding under 406, 409 to put me under pressure. And there is another judgment of this honorable court, if your lordship considers the same. Malad, it's reported in 2009, volume 2, CHN, page 406, by a coordinate bench.
Yes.
Malad, if your lordship would kindly see paragraph 3 thereof.
Yes.
Paragraph 3 and then paragraph, my lord, 7, 8, and 9. Well, they refer to two other judgments of this honorable court in 1896, and the other was of the Honorable Madhya Pradesh High Court in 1956.
Yes.
Now, in this case, the dispute even is with regard to immovable property. And the dictum of this honorable court is that it is not maintainable in respect of a immovable property. That has been the consistent stand from 1896 onwards, my lord. Therefore, this, with great respect, even the basic primary ingredients of the offense of 406 and 409 is only an aggravated part of 406. My lord, is not made out. And therefore, I was praying for a stay of the proceeding. Also on this issue. The first issue is obviously with regard to the fact that I was never entrusted with that property by the municipality. And therefore, there cannot be any question of misappropriation or conversion thereof.
Yes, who is appearing for the state?
Well, this is at the stage of motion.
Notice not served.
Well, at the stage of motion, the usual convention is that yes, notice is not served. Unless your lordship admits it, I cannot serve. That's why.
So appearing for the petitioner. The petitioner has filed the present application under section 528 of Bharatiya Nagrik Suraksha Sanhita 2023, praying for quashing of the proceeding of Darjeeling Sadar Police Station case number 49 of 2025, dated 30th April 2025, under section 316 within bracket 2/316 within bracket 5 of the Bharatiya Sanhita 2023, pending before the learned court of Chief Judicial Magistrate at Darjeeling, being GR case number 103 of 2025. Police staff. Counsel for the petitioner submits that as per the e-auction notice, the petitioner had purchased, petitioner has participated in the said e-auction, and accordingly the petitioner has deposited an amount of rupees 2 lakh with the Darjeeling Municipal Corporation, municipality. Darjeeling Municipality.
Well, that is a separate action by me. Well, in the e-auction, I had paid a total sum of rupees 1.5 crores, 1.58 crores.
Participated in the e-auction process. And according the petitioner has deposited. Where is your amount deposited received?
That your lordship will get at page 28.
And the petitioner has deposited an amount of rupees 1 crore 53 lakhs 85,000.
1 crore 53,085, 53 lakh 85.
1 crore 53 lakh 85,000 with the Union Bank of India. Which branch? Calcutta?
The Darjeeling branch.
Union Bank India, Darjeeling branch.
Well, yes, your lordship will get the fourth line. Sold on behalf of
Darjeeling branch. Darjeeling branch. Full stop. Subsequently, the petitioner has deposited an amount of rupees. And subsequently, the petitioners. 3 petitioners are there.
Well, 2. The third is not accused in the FIR, my lord.
Petitioners have applied before the chairman Darjeeling municipality for grant of fresh lease, and as per the request made by the petitioner by the letter dated 29th of May 2023, the Darjeeling municipality has accepted the request of the petitioner and have entered into a lease, and according the petition has deposited an amount of rupees 2 lakhs with the Darjeeling municipality. Police. Subsequently, a complaint has been lodged against the petitioners as well as the earlier chairperson.
Yes, my lord. Erstwhile chairperson.
As well as the erstwhile chairperson, namely Ritesh Portal, and erstwhile chairperson of the Darjeeling municipality before the police of PS Sadar Darjeeling, alleging that the municipality property, being a public assets registered under the authority of the municipality, had an assessed market value of rupees 1,53,85,000 as per the documentation dated 8 June 2018. But despite of the valuation, an application dated 29th March 2022 was submitted by the petitioners and petitioners to the municipality, and thereafter on 3rd August 2022, the S12 chairperson, acting in collusion with the petitioners, unlawfully approved the lease of the municipality to the petitioners with the undervalue of rupees 2 lakhs. Police. On the basis of the said complaint, the police has registered the instant case against the petitioners and the erstwhile chairman of the Darjeeling municipality for the offence under section
316 subsection 2 and
section 316 within bracket 2/316 within bracket 5 of the Bharatiya Nyaya Sanhita 2023. Police. On 30th April 2025, police consider the submission made by the counsel for the petitioner. This court find that the petitioner, counsel for the petitioner relied upon the judgment in the case of Farid Malik versus State of West Bengal and another, reported in 2009 SCC Online Calcutta 224, wherein the coordinate bench of this court has held that immovable property cannot be subject matter of criminal breach of trust. Police. And the learned counsel for the petitioner peruse the materials on record and the judgment relied by the parties. This could find that the chairman municipality has made a complaint with regard to the lease entered between the petitioner and the municipality with municipality, and at that point of time, the erstwhile chairperson at that point of time, Mr. Ritesh Potal was the chairperson of the municipality, and some allegation has been made against the said chairperson. Considering the above, this court find that the matter is to be find that the petition has made out the arguable case and is to be heard after notice to the parties, to the opposite parties. Accordingly, the petition is directed to issue notice upon the opposite parties and to file affidavit of service on the next date fixed. Pending disposal of the present criminal revision application being CRR 231 of 2025, the further proceeding of FIR number of Darjeeling Sadar Police Station case number 49 of 2025 dated 30th April 2025 is stayed for a further period of 6 weeks from date.
I'm deeply obliged to your lordship, deeply obliged.
Next the matter before the next circuit bench. Next. Page.
Lord, I am for the petitioner, my lord. May it please your lord.
Yes.
Lord, the petitioner before your lordship, my lord, is an accused in an offence arising out of the Poxo Act. Lord, in the matter, the charge sheet was filed.
What your challenge?
Lord, I have challenged a specific order of the trial court by which, my lord, the legal aid counsel was called in court. He was asked to, my lord, cross-examine the victim witness, the victim girl, in the absence of the defense counsel. My lord, the defense counsel, privately engaged defense counsel, retired on that very day. And my lord, without giving any reasonable opportunity, my lord, our defense counsel was called on the same day. My lord, he was asked to cross-examine the witness, and my lord, the court proceeded on this basis.
So what do you want?
My lord, just a minute, my lord, may I submit in brief? My lord, this petitioner, my lord, after the charge sheet was filed, my lord, throughout the entire trial, my lord, I mean, from the starting of the proceedings, he was being represented by a private counsel. My lord, on the date of examination of the victim girl, my lord, due to some miscommunication with the family members of the petitioner, my lord, the defense counsel went before the court. My lord, he expressed his intention of retiring from the brief, and my lord, he straight away left from the court. My lord, what the learned trial court did, on the same day, my lord, he called the defense legal aid counsel. My lord, at 12 o'clock, he asked the defense counsel, the legal aid counsel, to proceed with the cross-examination.
Victim was present on that day.
Lordship?
Victim was present
Victim was present on that day.
And the earlier defense counsel refused to cross-examination.
He refused to participate in the proceedings.
Correct.
Yes.
He found that the victim was present, the examination is to be done, but he has
He
withdrawn.
refused, yes, and he retired.
Then the court has appointed the legal aid advocate. Yes.
Directly, my lord, the court has appointed a counsel, and my lord, without any preparation, my lord, he prodded the defense counsel to proceed. Now, my lord, the defense counsel prayed for an adjournment. My lord, the newly engaged defense counsel prayed for an adjournment, but my lord, that adjournment application was also not taken on record. My lord, there is no reflection in the order, my lord, that a adjournment prayer was made, and the court is refusing the same. My lord, without any instruction, without any conference with the petitioner lodged in the correctional home, my lord, simply straight away he had proceeded on the proceeding of the trial court. My lord. Now, my lord, the the family members of the petitioner, my lord, engaged a new counsel, my lord, next day. My lord, the new counsel, after inspecting the records, finds that the application for adjournment is not there in the law. My lord, he prays for obtainment of certified copy.
Cross-examination done.
Done. My lord,
Who has cross-examined?
My lord, the newly engaged counsel engaged at 12 p.m. without going through anything, without taking instructions from the client. My lord, cross-examined because the trial court was insisting. Now, my lord, the newly engaged counsel finds that the application is not on record. Neither the order says anything about the said application for record. My lord, the trial court, my lord, refuses to give copy at first.
What?
My lord,
copy?
I may be very candid. My
What
lord,
copy?
My lord, the copy, certified copy. On 5th of this month, my lord, I had applied for certified copy.
When the victim was examined?
30th of April.
And you applied on certified copy on?
5th. In between Saturday, Sunday.
Okay, whatever it is.
Yes.
So you have not received the copy?
No, I have received on 15th.
15th of May.
15th of May. And after that, my lord, I have filed this application.
What is your prayer now?
My lord, my prayer
What is your
is,
challenge?
I am challenging, my lord, that the evidence be expunged. My lord, I may be allowed to, my lord, re-examine, and my lord, the court has to be shifted. My Milord, I am on a point of law. I am on a point of law. Milord, a vital witness. Milord, the victim in a Poxo case is a vital witness. And Milord, without giving any time for preparation, Milord, in this manner, Milord, the victim cannot be cross-examined. At least 2 days time should have been given. Milord, I rely on a judgment of the Honorable Supreme Court, Milord, exactly identical point. Milord, page number 27. Paragraph number 20.5, Milord, last.
Page 27?
Yes, Milord.
Yes.
Para 20.5, last.
Yes.
In Bashira as well as in Ambadas, making substantial progress in the matter on the very day after a counsel was engaged as amicus curiae, was not accepted by this court as compliance with sufficient opportunity to the counsel. In the present case, the amicus curiae was appointed on 19th February 2013, and on the same date the counsel was called upon to defend the accused at the stage of framing of charges. One can say with certainty that the amicus curiae did not have sufficient time to go through even the basic documents, not the advantage of any discussion or interaction with the accused, and time to reflect over the matter. Thus, even before the amicus curiae could come to the grips of the matter, the charges were framed. Next, Milord 23. In our considered view, the trial court on its own ought to have adjourned the matter for some time so that the amicus curiae could have had the advantage of sufficient time to prepare the matter. The approach adopted by the trial court, in our view, may have expedited the conduct of trial, but did not further the cause of justice. Not only were the charges framed the same day as stated above, but the trial itself was concluded within a fortnight thereafter. Yes, in that matter, Milord. In the process, the assistance that the appellant was entitled to in the form of legal aid could not be real and meaningful. Next, Milord, 26, page next page. Expeditious disposal. Expeditious disposal is undoubtedly required in criminal matters, and that would naturally be part of guarantee of fair trial. However, the attempts to expedite the process should not be at the expense of the basic elements of fairness and opportunity to the accused, on which postulates the entire criminal administration of justice is founded. In the pursuit of expeditious disposal, the cause of justice must never be allowed to suffer or be sacrificed. What is paramount is the cause of justice, and keeping the basic ingredients, fast tracking, which secure that as a core idea and ideal, the process may be expedited. But fast tracking of process must never ever result in barring the cause of justice. In the circumstances, going by the principles laid down in Bashira, we accept the submissions made by Mr. Luthra, the learned amicus curiae, and hold that the learned counsel appointed through legal services authority to represent the appellant in the present case ought to have been afforded sufficient opportunity to study the matter, and the infraction in that behalf resulted in miscarriage of justice. In the light of conclusion that we have arrived at, there is no necessity to consider other submissions advanced by Mr. Luthra, the learned amicus curiae. So, Milord, this was the ratio of the Honorable Supreme Court in Anokila. Milord, what I have submitted is one limb. Milord, another limb is the accused was not physically produced on that day. He was not present before the court. Milord, though the court has stated that he was present virtually, but Milord, the process of virtual appearance of accused in courts, Milord, is Milord, it has no relevance, Milord, for the purpose of such trials. Because what happens, Milord, in the beginning of the day and at the end of the day, Milord, their attendance are taken over virtual conference. But at the time when the evidence was being conducted, Milord, he was not there. So, Milord, the accused person was not in a position to hear what the victim has adduced as evidence. Now, Milord, if he does
why through the virtual mode? Why it cannot be able?
He was not there, Milord.
The virtual mode,
he was not there in the virtual mode as well. He was there in the present in the first time of the day, first sitting of the court, and at the time of rising of the court. But during the period of the evidence was done, Milord, he has not heard anything. And I have stated on oath, Milord, the family members went to the correctional home, talked to him and said that today your the evidence of the victim girl has been completed. And to this, Milord, he reacted saying that I do not know what happened. I have not heard anything. Milord, this is my statement on oath. The elder brother of the accused, Milord, has affirmed this application. And Milord, if this is found to be untrue, Milord, my client, the deponent, should be imposed cost.
Okay. And what is the stage of now? When
Milord, one witness has been examined.
Victim is examined.
The victim is examined.
When the next date is fixed?
Milord, just after the vacations, Milord. 21st of June.
21st.
Yes, Milord.
See, in the criminal trial, that is, the judgment is okay, but here the witness examined, cross-examined. But the opportunity has not been given with regard to the conduct. So it cannot be, if you suggest or you agree, I can give you a liberty to file an 311 application, call the witness and examine. On 311, you have to give what are the suggestion has not been given, what are the question as what is
But
required to be.
The difficulty is, Lord, my client, Lord, who is lodged in correctional home, he has not heard the evidence. Lord, if the accused has not heard the evidence, Lord, he cannot reply in 330.
Then I am fixing it because when the next date is fixed, 21st of June, when the next circuit, 9th June. So I am fixing before the next circuit, and I am calling for the report from the when the court is going to be closed in the lower court. No summer vacation. So I am calling the report from the district Judge Poxo court.
Yes, my lord.
Judge Poxo court, whether the accused was present in person or whether an opportunity he was present during the evidence of the victim through virtual mode or not, whether let he submit the report.
My lord, and one report may also be called from the defense counsel who had conducted.
For what?
The legal aid defense counsel.
And also, if you record, then I can also call a report from the jail superintendent, correctional home superintendent, whether at the time of evidence the video conferencing was provided to the petitioner from the correctional home. This can be done.
They will.
Because that's why. If it is that he was not present, then the situation would have been different. If he was present through the virtual mode, he heard it, and because in the criminal trial, even the CPC also, the evidence cannot be expunged at this unless and until it is set aside. How the evidence can be expunged when evidence of come on record that is recorded on oath? So you can get an opportunity. If you want, that opportunity will be given by allowing you to file an appropriate application before the trial court for recalling of the witness, and you can recall and examine.
The difficulty is the learned defense counsel proceeded at his own whims, without going through the record.
What can be
if that
done?
is not expunged, that will be binding upon me.
What can be done? That cannot be. Either you could not have been cross-examined, and the court cannot punish the advocate who has cross-examined.
No, court cannot do that. But that opportunity and that choice of engaging a private counsel was not afforded to me also. That since your earlier counsel has retired, do you want to engage?
Sitting here in the revisional jurisdiction, we cannot say what were the circumstances over there. There are several circumstances. Some of the advocates find that the victim came, he knows the judge will not give the adjournment, withdraw the wakalatnam. So who is fault? Court is fault.
No, it's not.
Or proceeding is fault.
My fault as well, Lord.
That's why. So you can't fault. But you could have been engaged the lawyer. If you are engaging a lawyer, private lawyer, you should know what is the capacity of the lawyer. If the lawyer says that the witness has come, he is not in a position to cross-examine, he withdraw that. So, and with regard to this Poxo, how time the prosecution will directed to bring the witness in the Poxo case?
Lord,
that is strict. There are strict guidelines.
I understand the rigors of law, Lord, but at the same time, Lord, being the accused, Lord, my rights are.
Yeah, that's what I'm telling. What you are telling, for that two things, that's why I am giving two suggestions. I am fixing because the 24th of June, before the vacation, the circuit is there. It can be, I fix on the very first day it will be taken. In the meantime, I will call for the report from the district judge and the correctional home authority, whether he was present on the virtual mode or not.
Milord, and additionally, Milord, whether time was, that is, Milord, admitted time was not given. Because on the very same day he was appointed and he was asked to cross.
That is there. That is not the problem. That's why. That's why for that purpose, the court can give a chance to recall the witness. If any further question is required, you can examine the witness on recall.
My lord, I bow down.
That can be done.
Let that be done.
That can be done.
My lord, report may be called for in the meantime.
So and so offering for the petitioner. Full stop. The petitioner is present and the petitioner has filed the present application. Present application. Challenging the order dated 30th April 2025. Passed by the learned Judge Poxo Court in case number 135 of 2024. In connection with Jalpaiguri Police Station case number 351 of 2024 dated 12th August 2024 under section 6 of the Prevention of Children from Sexual Offences Act 2012. Pending before the Additional Session Judge Poxo Court, Second Court, Jalpaiguri. Counsel for the petitioner submit that the petitioner is in correctional home and facing trial of the above case before the Learned Judge Poxo Court. On 30th April 2025, the victim was present, but unfortunately, the advocate engaged by the petitioner who was in correctional home has withdrawn his power. Yes. Has withdrawn his power on the same day. And the learned Judge Poxo Court has appointed another advocate from the legal aid on behalf of the petitioner who was in correctional home. And without giving an opportunity to the learned legal aid counsel to go through the record and to consult with the petitioner who was in correctional home has directed the learned advocate to cross-examine the victim, and accordingly, the learned advocate who has been engaged through the legal aid has cross-examined the victim. Full stop. Counsel for the petitioner further alleged that the petitioner was not produced before the learned Judge Poxo Court on the date fixed in person. Even he was not present through the virtual mode. And as said, the petitioner has no knowledge with regard to the evidence adduced by the victim. Counsel for the petitioner submitted that when the family members of the petitioner came to know that the victim was examined and legal aid counsel appointed by the learned judge has cross-examined the witness without taking any instructions from the petitioner, immediately the parents of the petitioner has engaged the present lawyer. Yes. Engaged the present lawyer, and the lawyer has gone through the record and find that the victim has been cross-examined on the same day by the advocate who has been engaged to the legal lawyer. Accordingly, the petitioner has filed the present case, praying for expunging the cross-examination of the witness and to allowing the petitioner to cross-examine afresh after taking the instruction from the petitioner who is in correctional home. This court finds that the petitioner has made out an arguable case and is to be heard in presence of the state. Accordingly, the petitioner is directed to issue notice upon the state and to file the affidavit of service on the next date fix. The counsel for the petitioner informed this court the next date is fixed before the learned court and learned trial court on 24th of June 2025. 21st of June 2025 for further evidence. Yes. For further evidence. In view of the above, let the matter be placed before the next circuit, which is going to be commencing from 9th of June 2024, so that before 21st of June 2025, this application can be disposed of. In the meantime, in the meantime, this could find that the petitioner has raised the issue that the petitioner is in correctional home on the date when the victim was examined, and the victim has not, and her evidence has not been recorded in his presence, either appearing in person or through the virtual mode from the correctional home. In view of the above, the Special Judge Poxo Court, Special Judge Poxo Court, Jalpaiguri. That will suffice. Special Judge Poxo Court, Special Judge Poxo Court within bracket learner additional. Special Judge Poxo Court.
Second court.
Special Judge Poxo Court, Poxo Court, Second Court, Jalpaiguri is directed to submit report before this court on or before 9th of June 2025 to clarify whether on 30th June, 30th April 2025, that is on the date of examination of the victim in the present case, whether the petitioner was produced from the correctional home before the court, or whether the petitioner, whether the petitioner has given an opportunity to see the proceeding and the evidence of the victim girl through the virtual mode from the correctional home. Police stop. The superintendent, here is the superintendent district correctional home, what
Yes.
we call?
Yes.
Superintendent of
The superintendent correctional home of what? Jalpaiguri?
Jalpaiguri.
Superintendent correctional home Jalpaiguri is also directed to submit report before this court on or before this court through the learned advocate appearing for the state to clarify that whether on 30th April 2025, whether the petitioner was produced before the learned Special Judge Poxo Court, or whether the petitioner has given opportunity to appear through virtual mode from correctional home at the time of recording of evidence of the victim girl by the trial court. Full stop. Let the matter appear before the next circuit bench, and the petition is directed to communicate this order to the learned district judge and learned special judge Poxo Court, as well as to the superintendent correctional home Jalpaiguri for compliance, and to file affidavit of service on the next date.
Item number 101. Or I am for the petition.
Yes.
Or here is my affidavit of service.
Lordship, to short the time, I straightway take you, Lordship, to page 23. Is relaxation of bail, but see the conditions.
23.
23.
Acha, that 2020 lakh rupees.
Lordship. No, I don't have anything.
My lord, thereafter I filed a modification, and my lord, the modification order is page 26 by the learned trial court.
Now 50 has become 35 lakhs.
My lord, my
10,000 with the capacity of 35. I have nothing to say. 10,000 taka local with the capacity of landed property of.
If he has given the surety of 20,000, yes, Mr. PP in charge, if the London court has given the surety of bail bond of 20,000 with two surety of 10,000, then what the 35 lakhs will do?
Misconception.
And that to Jalpaiguri town. We'll give Lordship 35 lakhs property.
So you could have been taken the solvency certificate of the court building.
Another order should be there, it should be opposite to the new High Court building, my lord, the landed property. So that in the later person, the government can take it and do some personal purpose.
Where is the first order?
23, page 23.
That's the first order.
Yes.
Page 23 is the first order.
The 50 lakhs.
50 lakhs. Then second order?
Page 26.
That's 35 lakhs.
26.
26.
35 lakhs. Within the
Jurisdiction of
Jalpaiguri town.
Town. I have nothing to say.
So suffering for the petitioner. The petitioner has and so suffering for the estate. The petitioner has filed the present application, being aggrieved and dissatisfied with the order number 18 dated 26th March 2025 and the order number 20 dated 9th April 2025, wherein the learned special judge Poxo NDPS court, first court Jalpaiguri, has initially granted interim bail. Interim bail.
So statutory bill they paid, interim bill was granted.
Granted interim bail after the period of statutory.
Dear Lordship,
After the statutory period.
indivisible right goes.
After the statutory period of rupees 20,000 with two sureties of rupees 10,000 each, and one of them must be local, having landed property worth of rupees 50 lakhs within the local limits of Jalpaiguri town. Subsequently, on the prayer made by the petitioner for modification of the order dated 26th of March 2025, the learned judge special court NDPS first court Jalpaiguri has modified the order dated 26th of March 2025 by allowing the petitioner to find interim bail of rupees 20,000 with two sureties of rupees 10,000 each, one of whom must be local, having landed property of rupees 35 lakhs instead of rupees 50 lakh within the Jalpaiguri town.
Next part I could not understand.
Within the Jalpaiguri town.
Town and
the other
registered means I fail to understand.
Jalpaiguri town, full stop. I stopped there only. Full stop. The counsel for the petitioner submit that the petitioner is entitled to get the statutory bail as the prosecution failed, as the prosecution failed to file the charge sheet within the statutory period of time. Instead of that, the learned judge has allowed the interim bail to the petitioner, and directing the petitioner that one surety should be local, having the property worth of rupees 35 or 50 lakhs, that too in the Jalpaiguri town, and subsequently that was modified that the property should be 35 lakhs within the Jalpaiguri police stop. Considering the above, this court failed to understand for what purpose the learned judge has directed the petitioner to furnish surety of one surety who is having the property of 50 lakhs or rupees 35 lakhs. Once the court find that the prosecution has failed to file the charge sheet and the petitioner is entitled to get the default bail, the court has to offer the bail, and at the time of offering the bail, the default bail, there must not be any stringent condition which the petitioner/accused cannot comply with. Considering the above, this court find that the condition imposed by the learned special judge NDPS court, first court Siliguri, Jalpaiguri, by directing the petitioner to furnish the surety, one local surety, having the property of rupees 35 lakhs within the Jalpaiguri is not in accordance with law, and accordingly the same is set aside. Full stop. The order passed by the learned judge special court NDPS first court Jalpaiguri is modified, and the order passed by the dated 9th April 2025 is modified by directing the, by allowing the petitioner to find bail of rupees 20,000 of two surety of 10,000 rupees each, out of which one surety must be a local. The other conditions remain same.
Yes, Your Lordship. This amounts to rejection of bail.
The condition of the police. CRR number 766, this is.
My lord, one prayer, my lord. 102.
My lord, 102, my lord, I am appearing on behalf of the petitioner, my lord.
Yes.
My lord, this is
I
my
have
lord.
my lord.
My lord, I have.
My lord, although my lord, this is a motion stage, my lord, but a copy has been served, my lord. Accordingly, I call CD has been called for, my lord. I am holding the
CD is
CD
there.
also, my lord.
What
My
is
lord, my lord, day before yesterday, your lordship had taken up the matter, directed me to serve. I have effected service, my lord. My lord, my junior friend, my lord, Mr. Das will hand up the affidavit of service. My lord, we have come up after, my lord, my prayer for discharge was rejected and charges were framed. My lord, proceedings, my lord, is under, my lord, 10 and 12 of the Poxo Act. My lord, are completely malafide proceedings. If your lordship kindly comes to page 23, my lord, of the file, my lord, kindly takes the charge sheet once, my lord.
Yes. So what
My lord,
you want to, you are praying for the causing of the proceeding.
My lord, technically, my lord, I will have to pray for a remand at this stage before your lordship. The reason is, my lord, under the, my lord, scheme of the Code of Criminal Procedure, my lord, your lordship knows, my lord, that 226, my lord, is the first stage where the prosecution opens its case. Then comes 227, where, my lord, the accused applies for discharge. And if discharge is rejected, thereafter, my lord, the charges are framed under 228. My lord, this is, my lord, the simple scheme of the Code of Criminal Procedure. If your lordship will find, my lord, two very glaring, my lord, deficiencies that have happened in this case. Firstly, my lord, in the charge sheet, in support of the charge under section 12, they rely, my lord, on, my lord, forensic evidence. And in the charge sheet, my lord, at page 24, my lord will find they record that supplementary report will be submitted on receipt of report from the director CFSL. Now, my lord, without that CFSL report, my lord, they proceed, my lord, for hearing on the issue of consideration of charge. And, my lord, without the public prosecutor opening the case in terms of 226, which, my lord, I will demonstrate from the order sheets. My lord, if your lordship kindly takes page 33 of the file, my lord. My lord, kindly sees order number 28 at page 33. My instruction is, my lord, subsequently, my lord, the forensic report has arrived. Perhaps my learned friend for the state might, my lord, be able to, my lord.
Yes. This is your application. Where is the order?
My lord, kindly have page 33, my lord. 33, my lord. 33.
Charge is also framed.
Charge is also framed, my lord. 33, my lord, will find my application for discharge is taken up, my lord, at a stage where the, my lord, FSL report was not there. Then, my lord, strangely at page 34, what the learned judge does is, the learned judge rejects my application under 227. Now, my lord, that is another issue that he can, and your lordship can, your lordship, we will address your lordship on the correctness of that. But what he does is, my lord, on the same day at 2 o'clock, he keeps the matter for framing of charge, and he records while taking up the matter at 2 o'clock that since there is no stay, so I am proceeding from no stay from a higher forum, so I am proceeding for framing of charge. Now, my lord, he himself has rejected the application in the morning. My lord, how can he expect that an accused can approach the higher court within 2 o'clock and obtain, my lord, an interim order, if at all? And then, my lord, if your lordship kindly comes back to page 32, which is the order framing charge, there, my lord, very strangely, kindly have, my lord.
Yes.
Kindly have, my lord, the fifth line from the top, my lord. The sentence starting with the learned special PP opens the case by stating the facts. So, my lord, here 226 is happening, my lord, after 227. And then, my lord, charges are framed without the Milord, without the Milord forensic report, that will, and that forensic report, Milord, I am told, Milord, has subsequently arrived. And Milord, the charges are framed. A complete, Milord, departure from, Milord, the procedure established under the Code of Criminal Procedure, Milord. And while deciding my 227, Milord, only, Milord, quotations of, Milord, Honorable Supreme Court orders, quotation of the section 227, and only one line I have perused and considered, and I am rejecting it, which, Milord, the Supreme Court has deprecated. That this. But, Milord, the fact of the matter is, Milord, the entire procedure, Milord, the Milord, cart has been placed before the horse.
No, but the case is fixed on 16.6 and 17.6 witness action.
That is the reason, Milord, I was requesting your Lordship. We filed this application, Milord, on that ground that it's very urgent, Milord. And if this can be taken up, and Milord, kindly, Milord, protect me till that time, and kindly, Milord, hear out the matter, Milord. Because day before yesterday, we moved it, we requested your Lordship to take up the matter. We have served also.
But as per the order, no objection raised by the learned advocate for the accused person.
That is also very strange, Milord, because the kindly see
of the accused is on bail.
Accused is on bail. Next line, next line. Next line, he records Nirdosh.
As per my record, my lord, on 4th May 2021, CFS has been sent to the Kolkata, and there is a more matter is pending. Therefore, the CFSL is returned back, and that is rescinded to the Guwahati on 6th May 2021, and still this is pending, my lord.
And without that report, my lord, they have framed charge under section 12. Their entire edifice of section 12 is the, my lord, mobile device which was to be examined, which they have sent for FSL, CFSL, my lord.
Okay.
So on that.
So what I propose to do, your case is fixed on 16th of June 2025, and the next circuit is coming on 6th of May, 9th of June 2025. I am sending it the next circuit, and let the PP come with the CD and all this. Then the matter can be heard it out before.
My lord, I will not bow down to what is falling from your lordships. My lord, only one request, if I may make, subject to my lord's consideration, is, my lord, that your lordship can, my lord, definitely, my lord, keep it returnable on 9th or 10th, as my lord will, my lord, decide. But, my lord, kindly grant me this liberty that on 16th, my lord, I may be permitted to pray for an adjournment, only on that. Because, my lord,
that is the anxiety of this court also, because this is the Poxo case and 2021 of the case, and now 4 years has been passed, and Learned Court has fixed on 16 June. So I will observe that because of the date fixed on 16 June of the witness action. So before that, the application can be heard. Let the matter appear before the next circuit on the very first day of the circuit. So let it argument.
My lord, I completely understand the anxiety of the honorable court, my lord, that this is a Poxo Act proceedings. Lord, but your lordship will kindly see, my lord, that, my lord, as a my lord, student of law, my lord, if I may indicate this to your lordship, that, my lord, in Poxo Act, my lord, the extreme expedition which is being shown by the learned special courts, my lord, that is also, my lord, counterproductive, my lord, because Poxo courts, my lord, are special courts which are not beyond the realm of Article 14, my lord. The court also should give an equal protection of law to the accused, my lord.
That's correct. But that's why I'm telling. So now you are having the time to challenge this order. You have filed this. I already admitted. I will admit this and fix the case for hearing on the next. Let it be for the first day of the circuit bench.
No. This is the first occasion.
So I am admitting.
No, my lord. On the previous day, my lord, day before yesterday, my lord had passed an order, my lord. Kindly see the order passed on the previous day, my lord, day before yesterday.
Find that the application is to be heard after giving the notice to the. Oh yes.
Lordship.
Wait.
My lord, can I make a prayer that my lord marks it hard in part, my lord, so that.
How it can be.
On 2 occasions, my lord has touched the matter, my lord. So if my lord, we can have the opportunity, my lord, to address your lordship here also, my lord, if your lordship.
No. Part in part can't be. Circuit bench hard in part can't be. It is the principal bench, you can go for the hardened part, but it is not possible in the circuit bench on today, tomorrow. I don't think the court will, the time will permit to this court to take up the lengthy matter, and this matter required hearings. This matter.
This indeed required.
Yes, required hearing, otherwise it will be difficult. So I am fixing on next, if you try before the next bench, if you got the order, it's okay, otherwise what?
Kindly fix it on 11th, my lord, instead of 9th or 10th.
So and suffering for the petitioner, so and suffering for the estate. The petition is filed the affidavit of service. Let the same be cut with the record. Due to paucity of time, it is not possible for this court to take the matter hearing today. Accordingly, case is adjourned. Let the matter appear before the next circuit bench, and let the matter appear before the on 9th or 10th. 11th.
Kindly make it 11th, my lord, subject to my lord's
for the
discretion, my lord.
And
liberty to pray for stay, my lord, on the returnable date.
Next circuit bench on 11th of June 2025.
Liberty may be granted to make up.
Due to the paucity of time, the court has not heard the application with regard to the stay of the proceeding. The petitioner is liberty to pray before the honorable court for stay of the proceeding on 11th of June 2020.
I'm deeply opposed.
My lord, one single discussion. I'm praying for not placing one application.
Which one?
Item number 12, Lordship.
Item number 12. Bail application. NDPS.
Yes.
So I will record, henceforth you will not file any further application for bail till the trial is completed. Item number 12. These are 12?
Yes, sir. Item number
166. Item number 12. So suffering with the petitioner. Counsel for the petitioner submit that he has instructions to not press the present application. Accordingly, on instruction, the counsel for the petitioner not pressing the present application. In view of the submission made by the counsel for the petitioner, CRM and DPS 166 of 2025 is dismissed as not pressed.
One humble prayer before your lordship, my lord. My lord, this is an extension of interim order. My lord, kindly.
Interim order give kal tomorrow it will be released. Kal rakho extension.
TPS matter.
Ah.
The narcotic seized is below the commercial quantity and principal accusation has already been granted.
Below commercial quantity, why you have? Go to the trial court.
The lordship, the application has been preferred for this order.
Why? If the
the matter is clear.
what is the quantum?
95 gram.
95 grams.
95 grams. Why the trial court has not given the bail? What is that? Ganja?
No, cocaine.
What is the narcotic?
Cocaine, my lord.
Cocaine, how it is in not commercial, small quantity?
100 gram is the commercial quantity, my lord.
Sure.
Yes, sir.
So why you have prayed for bail before the trial court?
Yes, sir.
Rejected. Have you enclosed the order?
Item number 88, lordship, is related to interim pair, lordship. Release of the cattle, lordship. That pair has been turned down by the London trial court. The cattle has, out of 80 lordship, 2 cattle has already been died, lordship.
Where is the cattle?
Cattle lying in the custody of the.
So what you will do with the cattle?
So there is a issue. I am enjoying stay order, but the
export.
No, not export. Transporting.
That's why exporting or transporting.
Transporting. For interstate transporting lordship, the cattle has been. There is no violation of law.
So why the cattle has been seized?
There is monetary issue and all lordship, corruption issue. That's why the court has passed a stay order of the entire proceeding. Not only that, lordship, only given liberty to consider the magistrate to pay for the release of the custody of the cattle that has been turned down, lordship. The item number 88.
Lordship, I am appealing for the OP3 in item number 18.
Item number.
ये सब को छोड़ दो, ये सब छोड़ दो। खाली भी नहीं आएगा, कोई नहीं लिख, खाली इनका जो मेंशनिंग वाला वो होगा और मेरा जजमेंट आएगा। उनका क्या नाम? 88
Item number 78.
88
Item number 79.
One indulgence, my lord.
To the following. Not kindly, my lord. One.
Proclaim one next.
Item number 74, my lord. Your lordship has
Warrant of
not
arrest
matter.
Not there. Otherwise, I. That was rejected. The CRR filed that.
China which matter?
That this list. Tomorrow's list.
See, tomorrow
Item number 74, my lord. Warrant of arrest
has had one matter and call for a police report, my lord.
74, my lord. 74.
74.